All right. Good morning. We are now on the record for Monday morning, January 24th, 2022, civil docket. And I'll start with quick announcements. Mr. Patino.
Good morning, Your Honor. I have a brief proof up of the divorce, Judge.
Okay. What number?
Number 3, Judge, on the court's docket.
Okay, F 3166-21-9 in the matter of the marriage of Jennifer Adame versus Ricardo Ociel Aviles.
Yes, Your Honor.
Okay. Ms. Aleman had checked in with the court stating that she was in another court for a hearing. Did you want to proceed without her? Did you have permission to proceed?
Yes, Your Honor. We can proceed without her. That'll be fine. I don't think she had any issues.
Okay. And so do you have a divorce decree that's already been executed by both parties?
No, Your Honor, we do not. For one reason is that we're unable to locate the husband right now. Mr. Aviles is not known where his location is.
Okay. Did Ms. Aleman have an opportunity to review the divorce decree?
No, Your Honor, she did not, because I have not prepared one yet.
Okay. But she's the ad litem for the unknown. Is that correct?
Yes, Your Honor, that's correct.
Oh, she's just logging in, Mr. Patino.
Yes, ma'am.
Let me go ahead and give her an opportunity to connect to audio. Ms. Aleman, can you hear me?
Yes, ma'am, I can hear you.
Okay, so Mr. Patino has a quick announcement on F 3166-21-9. Any objection to proceed?
No, ma'am, we're ready.
Okay, all right. So Mr. Patino, let me have Ms. Adame raise her right hand. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God, ma'am?
Yes. Yes, ma'am.
Okay, all right, just go ahead and speak up. You can lower your hand. If you can please go ahead and speak up so that my court reporter can get all of your responses on the record. Okay? All right, Mr. Patino, you may proceed.
Thank you, Your Honor. Please state your name, please.
Jennifer Adame?
You lived in Texas for at least 6 months
Yes.
and in Hidalgo County for at least 3 months.
Yes.
You're married to Ricardo Ociel Aviles.
Yes.
You were married on or about November 2, 2016,
Yes.
and you ceased to live together as husband and wife on about February 14, 2021.
Yes.
Are there children born into the marriage who are under the age of 18?
Yes. When?
What is the name and age of the child?
Kenny Adame, and he's 5 months.
Okay. Are there any children expected?
No.
Are you seeking divorce from Ricardo Ociel Aviles?
Yes.
Are you seeking divorce because the marriage has become insupportable due to discord or conflict between the both of you, such that any expectation of reconciliation cannot be expected?
Yes.
You do not know the whereabouts of Mr. Aviles at this time, is that correct?
No.
And you have not had any communication with Mr. Aviles since February 2021, is that correct? You asked that the court grant you sole managing conservator of your son.
Yes.
There is no community debt.
The what? I'm sorry?
Is there any community debt?
Oh, no.
Is there any community property?
No.
You're asking the court to grant you this divorce.
Yes.
I have nothing further, Judge.
What about child support? What are you going to be doing about that?
She's not requesting child support, Your Honor.
And the insurance, what type of health insurance does the child have?
Molina?
Okay, so the child is on Medicaid?
Yes, ma'am. Your
All
Honor.
right. Okay, so at the bare minimum, he has to at least be charged with the some type of medical reimbursement for that. The state has to have some kind of judgment against him. So medical support, I believe they're doing right now is $60.
Yes, Judge.
Okay, and in reviewing the pleadings, Mr. Patino, it does state on her petition for divorce that she has no children. So are you asking for a trial amendment at this time?
Yes, Your Honor, I am.
Okay. It could have been that maybe at the time she filed, she hadn't had the baby yet.
That
It
was,
might have been.
that's correct. That's exactly what happened.
Okay. All right, Ms. Aleman, any questions of Ms. Adame?
No questions, Judge. I do believe that in this case, service has been perfected. We have not been able to locate Mr. Ricardo Ociel Aviles, but at this time, service has been perfected and done.
Okay. Have you all come to an agreement as to your fees?
Mr. Patino and I have not discussed fees. That is something that we can discuss once we log off.
Okay. All right, then I'll give you an opportunity to do that. And make sure that Ms. Aleman has a copy of the divorce decree and that she also signs off on that divorce decree. The court is granting the divorce today and is granting the relief as requested. The only thing I'm adding is that there has to be medical reimbursement for the Medicaid that the child is on, and that'll be in the amount of $60 beginning on February the 1st.
Very well, Judge.
Okay, anything else?
Nothing further from me, Your Honor. Maybe would be excused, please.
Okay, I'm gonna set a tickler for February the 11th to make sure that the divorce decree has been submitted.
I'll have it way before then, Judge.
Okay. All right, thank you.
Have a good
Thank
day, Judge.
you.
Thank you, ma'am. Good luck to you. All right, thank you, Ms. Aleman, for your
Thank you,
assistance.
Judge. May I be excused?
Yes, you may be excused.
Thank you.
Thank you. Okay. Mr. Gomez,
Good morning, Judge.
good
I have-
morning.
I have number 29 on the docket.
Okay,
And for the record, Randall Gomez, I represent the defendant.
okay. It's CCD -0596-I Amadeo Cantu et al. Versus Allstate.
Yes, Judge. This
Okay,
book, this one, we have a status. This is a storm claim, and we recently had the property re-inspected, and then we scheduled depositions I think in about 2 weeks or so. And so after that, then we'll be able to proceed with mediation as the court ordered with, I believe, Daniel Hernandez.
yes. And is there anybody here? Is Ms. Sandoval here, or you have permission to make the announcement on behalf of both of you?
I'm in charge of the file for Ms. Sandoval.
Oh, okay.
And so that was just the announcement. We had communications with the plaintiff's counsel scheduling deposition and reinspection just recently. And thereafter, then we'll schedule the mediation with them.
Okay, so then do you want a 60-day status or a 90-day?
60 would be good.
Okay, March 21st at 9:30.
All right. Thank you so much, Judge. That's all I have. May I be excused?
Yes, sir, thank you.
Thank you.
Okay, let me see. All right, okay. Mr. Flores,
Good morning, Your Honor.
good morning.
I have 3 cases on the docket. The first one is number 4.
Okay, F-1920-20-9 in the matter of the marriage of Jose Chavez Jr. versus Ruby Hernandez. And what is your announcement, Counselor?
Joe Richard Flores, on behalf of Ruby Hernandez, Your Honor. I believe Isabel Trevino is on also.
That is correct, Your Honor. Isabel Trevino for intervener, the office of the state of Texas.
Your Honor, we've already, Mr. Jose Chavez, who's not represented, I believe his attorney had previously withdrawn. We've already had proven up the case. However, the only issue was child support and medical support, and I believe Mr. Trevino has all the information regarding that, Your Honor.
Okay, Ms. Trevino, go ahead.
That is correct, Your Honor, and this is based on information provided by Mr. Chavez. We figured out, Your Honor, a gross of $3,787.17 with a net of $3,357.03 for a child support payment of $839 with a step down to $671 and a medical support of $180, Your Honor. And this would begin February 1st, 2022.
Okay, and Jose Chavez, is he present today?
I did not see him, Your Honor, but he was notified of the hearing.
Okay. So now, and go ahead.
Sorry, there's also some arrearages.
Yes, I was about to go into those. The state is requesting, Judge, a child support arrears judgment of $4,356.80 as of November 30th, 2021, to be paid at $75 a month beginning February 1st, 2022.
And is there any arrears on the medical support?
No, Judge, there was not a medical support obligation previously.
Okay. All right. So then all you will be doing is inserting those numbers into the divorce decree so that you can have that submitted, Mr. Flores?
Yes, Your Honor.
All right. And how much time do you need for that?
I have almost everything ready. It's just plugging in those numbers. And that's about it, maybe a week or so.
Okay. Then the court is approving those numbers as put on the record by the Office of the Attorney General based on the information that they have been provided, and finds that that is within the child support guidelines. I'm going to set a tickler for February the 11th. Please make sure that Ms. Trevino has an opportunity to sign off and review the decree as well.
Yes, Your Honor, will do.
Okay. And then that way we can conclude that case.
Okay, thank you, Judge.
Okay, you're welcome. Your next case?
It's number 9 on the docket. That's an agreed divorce, Your Honor. I don't know whether Ms. Landine is on.
Okay, F 4428-21-9 in the matter of the marriage of Raquel Landine versus Mario Heredia.
Yes, Your Honor.
Raquel Landine, is Ms. Landine present?
Yes,
Yes, Your
Okay, there she is. Was Mr. Heredia going to be present, or was he going to stand by his waiver that he filed?
Honor. I don't know whether he was going to be present, but he did sign the decree, Your Honor.
he's here.
He's with you?
Right now, yes.
Okay.
Your Honor, we'll probably have to do this in Spanish because Mr. Heredia does not understand English or speak English. So-
Okay, well, when you ask him those questions, we'll have Ms. Castaneda translate, but just go slow, okay?
Thank you, Your Honor.
All right. Ms. Landine and Mr. Heredia, will you please raise your right hand? Ms. Castaneda?
Mr. Heredia, por favor, levanta su mano derecha.
Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Jura que el testimonio que está a punto de dar es la verdad, toda la verdad y nada más que la verdad.
Yes.
Yes.
Thank you.
Okay? And you may lower your hands.
Pueden bajar su mano.
Thank you, Your Honor. May I proceed?
Yes.
Ms. Landine, please state your full name for the record.
Raquel Landín.
Prior to the filing of this petition for divorce, did you reside in this state and county for 6 months?
Yes,
And were you married on October 19th, 2006?
yes,
And you separated on or about December 2018?
yes,
Are you asking for divorce because your marriage has become insupportable due to conflict of personalities that destroys the legitimate ends of your marital relationship?
yes.
Do you think that you and Mr. Heredia will ever get back together?
No,
Now, you have 3 children under the age of 18. That's Ixmena, born June 6, 2006, Ixtali, born September 29, 2010, and Xorani, born February the 3rd, 2015. Is that right?
yes,
Now, both you and Mr. Heredia have agreed that both of you will be joint managing conservators. However, you will be the person to have the exclusive right to designate the primary residence of the children. Is that right?
yes,
And he'll have the right to visit the child pursuant to the family code in terms of visitation.
yes,
In terms of child support, he has agreed to pay you $815 a month starting on February the 1st, 2022, with step downs of $679 and $543. Is that correct?
Yes,
And also he will, I believe you have insurance available through your employer. So you're asking this court that he can reimburse you $50 a month for health insurance and medical insurance. Is that right?
yes,
In terms of property, you're asking that you be awarded the 2016 Toyota Corona, the 2017 Nissan Altima, and all other furniture, bank accounts, cash, and personal items in your possession.
yes,
And Mr. Heredia can keep the 2016 GMC Arcadia and all other furniture, bank accounts, cash, and personal items he may have in his possession.
yes,
Okay. In terms of debts, you're going to be responsible for the balance due on the note regarding the purchase of the 2016 Toyota Corona and 2017 Nissan Altima. Is that right?
yes,
As well as all other debts incurred after your date of separation.
yes,
He will have the debts regarding the note to Wells Fargo on the purchasing, on the balance of the 2016 GMC Arcadia that he purchased. And
yes,
all other debts that he may have incurred after the date of separation.
yes,
Are you asking that the court grant this divorce?
yes.
Thank you.
Okay. And the questions that you have of Mr. Heredia, like I said, just go slow, okay?
Thank you.
Okay.
Mr. Heredia, did you review the decree of divorce?
Señor Heredia, ¿usted tuvo una oportunidad de revisar el decreto del divorcio?
Sí,
Yes.
And you understand the provisions set forth in the decree of divorce regarding child support, medical support, and the division of community property?
¿Y usted entendió lo que va a ser la manutención de los niños tocante el aseguro y la división de propiedad?
sí,
Yes.
And so you're in agreement with this divorce, is that right?
So, ¿usted está de acuerdo con este divorcio?
sí.
Yes.
That's all I have, Your Honor.
Okay. Then the court is granting the divorce today and granting the relief as requested and testified to on the record. And did you say that they've already signed off on that decree?
Yes, Your Honor, they did, and I submitted it on Friday.
Okay, then I'll ask my staff to ask the clerk to forward it to my queue for signature.
Thank you, Your Honor.
Okay. All right. Anything else from these parties?
No, Your Honor.
Okay. So Ms. Landon and Mr. Heredia, you are excused and best of luck to you. Ms. Castañeda?
Señor Heredia, están divorciados y buena suerte para todos.
Gracias.
Gracias.
Thank you.
Okay, your next case, Mr. Flores?
It's number 11. I believe Mr. Matulis is also on online, I believe.
Okay, F-1808-21-9 in the matter of the marriage of Rosie Flores versus Mauricio Ramos.
Anthony Matolich on behalf of Rosie Flores.
Your Honor, George Flores, and the ad item for Mr. Ramos, Your Honor.
Your Honor, this is a straightforward divorce case. They've been separated for more than 10 years. We cannot find Mr. Olivera. So I can either go with an offer of proof right now, or I can bring Ms. Flores and give her testimony, but we've agreed it's a very simple case, as simple as they come. And Mr. Flores can correct me if I'm wrong.
Your Honor, this is a case where there's no children and there's no community property. Everything that has been filed by Ms. Matulis is correct. So I have not been able to locate Mr. Ramos. I believe he's probably in Mexico. And frankly, I don't know where he's at. So it's a simple divorce.
Okay, well, since there's no children involved and no community property, and there's an ad litem that's already been assigned, I'll go ahead and allow you the opportunity to just circulate the divorce decree for signatures and make sure that Mr. Flores' signature is also on there.
It's been filed, Your Honor.
Okay, then I'll ask for that to be forwarded to my queue. And Mr. Flores, have you all discussed your fees?
Yes, Your Honor, everything's been taken care of.
Okay, perfect. All right, well then, best of luck to your client, sir.
Thank you, Your Honor.
And we've
Okay.
excused.
Yes,
Thank you.
all right. Okay, Mr. Ramirez?
Yes, ma'am. Good morning. Daniel Ramirez, number 33 on your docket, Judge.
Okay. And that is F 4741-20-9 in the matter of the marriage of Melissa Gonzalez versus Gerardo Gonzalez.
Yes, ma'am. I represent Melissa Gonzalez. Mr. Gerardo Gonzalez had an attorney at one time who withdrew, and so he's pro se at this time. Today is a status hearing, Judge. There had been some delay in getting to mediation because a mediator was having difficulty contacting Mr. Gonzalez. My office assisted the mediator in contacting Mr. Gonzalez. Mr. Gonzalez came to my office and he wants to settle the case.
Okay,
So we're going to be trying to see if we can settle the case with him without having to actually spend money on a mediation. And then we're going to proceed with a filing of a motion for a final hearing, Judge.
okay, and then what I'll do is, so do you think that you'll have that done within 60 days or 90 days?
No more than 60 and hopefully a lot sooner.
Okay, well then what I'll do is I'll go ahead and set you for a final hearing on March the 21st
Okay.
at 9:30. And if you do get it settled sooner and you need an earlier date, just go ahead and contact us and we'll accommodate you.
Thank you, Your Honor.
Okay, anything else?
No, ma'am. Thank you
All
very
right.
much for your time.
Okay, you have a good day.
You too, ma'am.
Thank you. Ms. Fuentes Aguilar?
Yes, good morning, Your Honor. I'm here today on Robert Dale Mortland's case, F 5488-219.
Okay, do you know what number that is?
28, Your Honor.
Okay,
Your Honor, my client is here. He's in my office. I don't know if you can see him on the screen, but this is essentially a change of name of an adult. Mr. Mortland's legal name is Robert Dale Mortland. However, most of his life he's gone by Dale Robert Mortland. So his first name and last name have been interchanged. Only few of his legal documents have the correct name.
so
He would like,
his first name and middle name were interchanged?
right.
Oh.
His legal name is Robert Dale, but he's always gone by Dale Robert.
Okay. Mr. Mortland, can you hear me? Oh, he's on mute. If somebody can help him unmute?
Yes, my assistant's going over, Your Honor.
Okay.
Go ahead.
Yes, Your Honor.
Okay, sir, can I have you raise your right hand, please? Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Okay, you may lower your hand. All right, you may proceed.
Thank you, Your Honor. Sir, your legal name is Robert Dale Mortland,
Yes,
and that appears on your birth certificate and on your Iowa driver's license. Is that correct?
no, on my birth certificate,
Okay, and what's on your driver's license?
Dale Robert.
Okay, and what name are you asking this court to change your name to?
Dale Robert.
And is that the name you've always used?
Yes,
And you're having trouble with Texas and getting your license renewed because of the birth certificate having what really is your name, Robert Dale. Is that correct?
yes,
Okay, but most of your legal documents have Dale Robert, which is the name you're asking the court to change to, correct?
my passport has Robert Dale. Everything
Okay.
else as Dale Robert. My
Okay,
social security, enlistment in the Army, diplomas, etc.
okay. And you filed a petition which has your date of birth, your driver's license, your social security number, and all of those numbers are correct. Is that right?
Yes,
Okay, for privacy, I don't want to repeat them on because we're on YouTube. So, but you had a chance to look at the document and it's correct. Is that right?
yes, Your Honor.
Okay, and you've never been convicted of a felony?
No, Your Honor.
Okay, and you don't have to register as a sex offender, is that correct?
Yes, Your Honor.
Okay, and you're asking the court to change your name?
Yes.
Judge, I have nothing further. As he stated, most of his legal documents already have the name he wants, which is Dale Robert. I believe he said his passport and his birth certificate have Robert Dale.
Okay. The only thing that I'm seeing on here is I do see that he had attached, for some reason, the fingerprint card to the original petition. However, I don't see the state's documentation with respect to the criminal history.
Judge, and I think when your staff, when we were asking to set this for a final, because my client has a deadline with Texas to renew his license, we looked into that, and from what we were in doing the research, it's not a requirement. If the court requires it, I obviously will do it. I think the problem is that my client's running up against a state imposed deadline on his driver's license. And so he's concerned about that.
Okay, so you're saying you're making that it's not statutorily required?
I could not find it in the family code, Your Honor, and I even asked a couple of those different blogs about it, and nobody had ever said it has to be done. I mean, I didn't hear from anyone saying that there was a law that I couldn't find that required it.
Okay. All right, well, being that the circumstances that he's in, the court is going to grant his name change to be Dale Robert Mortland, and I saw that the order is on file. I'll ask for that to be forwarded to my queue. And then I'll sign off on it as soon as it hits my queue so that you can have your copy so he can get that done.
Thank you, Your Honor. We appreciate your consideration.
Okay, anything else?
Nothing further.
All right, best of luck to you, sir.
Thank you.
Okay, take care. All right, Karina Murillo.
Yes, Your Honor.
Okay, I know you put number 9, but you're not number 9 on my docket. Are you here on?
Number 2. I'm sorry, number 2.
Oh, number 2, okay.
My bad.
F3222-21-9 in the matter of the marriage of Karina Murillo versus Jesus Alvarez. And
Yes,
ma'am,
ma'am.
you're representing yourself today?
Yes, ma'am.
And are you ready to proceed?
Yes.
Okay, and is Mr. Alvarez present?
No, Your Honor.
Okay, let me just look up your case very quickly.
Thank you.
So I see that Mr. Alvarez executed a waiver of service. Is that correct?
Yes, Your Honor. He also signed the final decree of divorce.
Okay. Okay, I don't see that child support has been set here. Did you all agree to a child support amount?
No. I was not requesting child support. I didn't know what to put on there.
And what type of health insurance does your child have?
She has Medicaid.
Okay, he is required to reimburse the state for that.
Okay.
Okay, you also didn't attach the possession order for the children. It states on there that it should be attached as an exhibit. And you don't have it attached on here.
I apologize, Your Honor.
Let me see. Do you have contact with your husband?
Yes.
Okay. And the other thing too, ma'am, is I'm looking at the waiver of service and the divorce decree, and the signatures for him look different. So with all these discrepancies, I'm going to need for Mr. Alvarez to also be present for the next hearing.
Okay.
Between now and then, I do need for you to file an amended divorce divorce decree that attaches the standard possession order as the exhibit. And Mr. Alvarez will need to be here to also testify as to the terms, so that he also understands that he will be responsible for medical support for the children, even though you're not asking for child support.
Okay.
And do you happen to know Mr. Alvarez's email address?
No, ma'am.
Okay. Do you have, I see that there was a change of address that was filed by Mr. Alvarez.
Yes,
Do you
no.
know if that address in Edinburgh is now the address? Oh, I'm sorry, he does have a email address here.
Okay.
All right. So his email address is alvarezchewy397@gmail.com. So that's where the link will be sent for his Zoom information. So I'm going to give you some time to go ahead and get that filed.
Thank you, Your Honor.
And then make sure that you get that done. And then what I'll do is I will have you come back on. Give me a moment, please. I'll go ahead and have you come back on February the 28th at 9:30. Make sure that he knows of that date, and we'll go ahead and get that, and the link will be sent to the email address I put on the record. And please make sure that you update that divorce decree.
Thank you, Your Honor.
Okay, anything else?
No, would you mind repeating the one that I need to attach for my child, please?
Yes, it's because on the divorce decree, it says standard possession attached is exhibit A. So the standard possession order that you're going to be following needs to be attached to that divorce decree as the exhibit, or you need to include it in your divorce decree.
Okay, Your Honor.
Okay?
Thank you.
All right, anything else?
No, may I be excused, please?
Yes,
Thank you.
okay. All right, Ms. Hayward?
Hi, Your Honor. Good morning. We're
Good.
number 21 on your docket.
CL 23565-I, Minerva Gonzalez Flores versus Lower Rio Grande Valley Development Council.
Yes, and Rebecca Hayward for the defendant. I spoke with my opposing counsel, Mauro Ruiz, and we have come to an agreement on discovery. He's already sent over the Rule 11. So I just wanted to announce that I'm going to pass this hearing.
Okay, all right. Then if you need another hearing on this for whatever reason, just file an order resetting.
Okay, thank you so much. May I be
Okay.
excused?
You certainly may.
All right, thank you.
Thank you. Mr. Caso?
Good morning, Your Honor. I don't have the docket in front of me. My apologies on that, but this is cause number CL-21-0240-I. This is Heriberto Cantu versus Walmart. And
Okay, that's number 16 on the court's docket. Okay, go ahead.
I'm appearing on behalf of defendant. We just want to advise the court that plaintiff's counsel as well as defendant's counsel have settled this matter. So we will not need to be addressing the hearing on defendant's motion for summary judgment today.
Okay. When can I expect for the documents to be filed?
Let's see, it's January 24th. Normally, Judge, we can get him the settlement documents or a settlement check within a month. So I would say by the end of February, we should have a dismissal document filed with the court.
Okay, then I'll set a tickler for March the 4th,
Okay.
just to see if that's been done.
Okay. Thank you, Judge.
Okay, well, congratulations.
Thank you, Judge. May I be excused?
You certainly may.
Thank you, Judge. You have a great day.
Likewise. Okay, Mr. Garcia?
Good morning, Your Honor. We have number 12 on your civil docket this morning.
CL 21-0179-I, Belinda Ochoa versus Alyssa Alexis Elizondo.
Good morning, Your Honor. Gerardo Garcia with Tijerina Legal Group on behalf of the plaintiff. This is a friendly suit. Respectfully, Your Honor, we're asking for another 3 weeks reset. We've been having some trouble scheduling this hearing promptly or timely enough for our client to get the time off from work. To remind the court, she was here at the last setting, but we weren't able to proceed then. And the second setting was an issue for her to attend. She works as a surgical coordinator for a local surgeon. And Monday's the busiest day of the week for them. So respectfully, Your Honor, 3 weeks should be able to be enough time for our client to get that time off from work, preferably on a Wednesday, Your Honor.
Okay, Mr. Guerra, did you need to make an announcement on this one? Okay, maybe not. All right, well then I have February the 23rd at 9:30.
That's perfect, Your Honor. Thank you.
Okay, anything else?
That concludes our business before this honorable court. May we be excused?
You certainly may.
I'm sorry, Your Honor. I just stepped away for a second. What was the date?
February the 23rd at 9:30. They requested a Wednesday.
That's fine, Your Honor.
Okay. All right, anything else on this case?
No, Your Honor.
All right, okay, thank you. Have a good day.
Thank you.
I have 2 other quick announcements, Your Honor.
Okay, go ahead.
It's first one is number 35 on your docket.
CL 23322-I, Jose Humberto Ramos Rivera et al. Versus Andres Sainz et al.
Good morning, Your Honor. Michael Guetta here for the defendants. We're set for a status hearing in my motion to compel depositions. I've been in contact with Mr. Galvan, and I expect his office to provide me dates, hopefully in the next week or so, Your Honor.
Okay,
That is correct, Your Honor. Carlos Galvan for plaintiff. We have been in contact with Mr. Guerra's office. I believe my staff is contacting them today, and we should have a date set soon.
All right. Okay, so do you want your next status for 60 or 90 days?
60, Your Honor.
All right, March 21st at 9:30.
Thank you, Your Honor. May we be excused?
You certainly may, sir. Okay.
My last announcement, Your Honor, is on number 36 on your docket.
CL 172275-I, Erica Ortega versus Victor Bravo Salinas et al.
Michael Guerra here for the defendants, Your Honor. This is a case in which Mr. Santos has settlement offers from me. I expect them to be taken, but he hasn't gotten back to me on this one yet.
Okay, was Mr. Santos making an appearance today?
I am not aware. I haven't spoken to him this morning, Your Honor.
Has he given you a timeline as to how long he needs to?
No, Your Honor. I made these offers, I believe, 3, maybe 4 months ago, and he always tells me he's going to get back to me.
I think that was the announcement the last time,
Correct,
and
yeah.
I believe that he was supposed to have seen if he could get it done before this one. So, well, I'll give you the March 21st at 9:30 as well. And if you need a setting prior to that, just go ahead and contact us.
Well, I certainly will, Your Honor. Thank you. That concludes my business before this honorable court. May be excused.
You certainly may, sir. Thank you. Okay, Ms.
Thank you.
Palacios Cruz.
Good morning, Your Honor. Number 5 on your docket.
Good morning, ma'am. Okay. F 3397-21-9 in the matter of the marriage of Kimberly Escobedo versus Cosme Escobedo.
That's correct, Your Honor. Audra Cruz on behalf of respondent Cosme Escobedo. Your Honor, we are set for, I believe, a final hearing this morning. I did contact opposing counsel's office, Orlando Jimenez. I have not heard back from him. They did send us over a proposed decree last week. We were not in complete agreement with that, Your Honor. So we're asking for about 2 weeks so we can iron out just some small issues in regards to geographic restriction and timeframes for visitation.
Okay. The next time that I have some room, I can squeeze you in on that February 23rd or February 28th.
Whichever is better for the court, that would be fine with us, Your Honor.
Okay, February 23rd at 9:30. And if y'all need a contested setting to figure those out, I'll be glad to give that to y'all.
And Your Honor, requires mediation prior to a contested setting?
Yes.
Thank you, Your Honor. We have not yet mediated yet. I did not see opposing counsel on the screen, so I took the liberty of making the announcement. I'm not sure if he will be joining.
Okay, well, go ahead and talk to him and see, and just notify us if you're going to need a contested setting and if you need a referral to mediation.
Thank you, Your Honor. Nothing further, if I may be excused.
Yes, you certainly may.
Thank you.
All right, Mr. Flores.
Good morning, Your Honor. I have number 1 on the court's docket.
Okay, F 1738-21-9 in the interest of Myralee Alvarado.
Abiel Flores for the petitioner in this case, Your Honor. I believe Mr. Joe Bravo is on as well. He's the ad litem on this case.
Okay,
Good morning,
Mr.
Your
Bravo. All right. Okay, Mr. Flores, and are you ready to proceed for final?
We are, yes, Your Honor. It's a prove up. I don't know if that's considered a quick announcement or not, but
Yes, sir. It's fine. Okay, and what is your client's name?
Eunice Barbosa. I saw her logged on as well.
Okay, Ms. Barbosa, can you hear me?
Yes, ma'am.
Okay, can you please raise your right hand? Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Okay, you may lower your hand. You may proceed, Mr. Flores.
Thank you, Your Honor. And I think Mr. Bravo has reviewed the court's file. I don't know if he has an announcement with regards to service.
Yes, Judge, I did have an opportunity to review the service on Ruben Alvarado, who is the respondent on this case. He is a non-resident, and service was perfected through citation by publication. There is one issue, Judge, and I did speak to Mr. Alvarado. This was done as filed as an original petition in the SAPSR, Judge. The mother of the child is a suit brought in by the aunt of the child. The mother, I believe, is not mentioned in the petition. My understanding is that the mother is deceased. And I believe Mr. Flores was going to be requesting a trial amendment to include the mother on the petition, Judge.
Okay, but as to the living biological parent, you do not have any issue moving forward today.
That's correct, Judge.
Okay, Mr. Flores?
Yes, Your Honor, at this point, we would make an oral amendment to our petition to include Marieli Barbosa Martinez as a party. She is a deceased mother of the subject child, Your Honor.
Okay, that'll be granted, sir.
Thank you, Judge. And if I could just question Ms. Barbosa briefly, Judge.
Yes, you may proceed.
Ms. Barbosa, can you please state your full name?
My name is Eunice Esteita Barbosa.
And Ms. Barbosa, you are the petitioner in this case with regards to the parent-child relationship of Mayrali Marie Alvarado, is that correct?
Yes, sir.
And you are the maternal aunt of the child, is that correct?
Yes, and I'm her godmother too.
Okay. And how old is Mayrali?
10 years old. She's going to be 11 on March 16.
Okay. And Marali's mother, what happened to Marali's mother?
On December 29th, 2020, the whole family got COVID. We came out positive. And then on January the 3rd, my mom went first to a hospital and then my sister, and then my dad on the 4th. And then on March the 3rd, my father passed away. And then on March the 9th, my sister passed away.
Okay.
Because of COVID.
And when you say your sister, you're talking about the mother of Mayrali Maria?
Yes, I'm talking about Marieli Barbosa.
Okay. And since her passing, where has Mayrali stayed?
Before we got sick, I was taking care of her already because my sister was kind of sick of diabetes, and she had her blood pressure, and she would get a lot of clogs on her legs. So she would go to the hospital and I would help her take care of her. But since they went to the hospital, I have been taking care of her until this day. Like today, I didn't send her to school because this morning she was feeling sick because she had a headache and she has cough. So later in the day, in the afternoon, I'm gonna take her to the doctor. But since then, she has been with me.
Okay. And Mayrali, does she have her own room in your house and everything?
Yeah, she has her own room, her own TV, her own aircon, her own bed set, her toys. She has her tablet, her phone. Like she has everything.
Okay. And so at this point, you've had possession, actual care, control, and possession of the child for at least 6 months. Is that your testimony?
Yes, sir.
Okay. And you're asking the court to appoint you sole managing concern. Oh, before I go there, the child's father is Ruben Alvarado. Is that correct?
Yes, sir.
And has Mr. Alvarado been a part of the child's life since birth?
He was with my sister only when she was pregnant. And he was here like for 2 months. Like I even let them live here in my house, but he was just here like for 2 months when she was born, and then he left, and we don't know anything about him.
Okay. So have you had any communication with him since the child was 2 months old?
No.
Has the child seen him since she was 2 months old?
Nope.
Okay.
I don't think so, because my sister wouldn't tell me, she wouldn't say anything.
Okay.
So I guess not, because he doesn't even live here. I don't even know where he lives.
Okay. And so at this point, you're asking for the court to appoint you sole managing conservator of the child. Is that correct?
Yes, sir.
Where you have all rights and obligations under the Texas Family Code, like we discussed. Is that correct?
Yes, sir.
You want to be able to make all medical decisions, school decisions, and all other decisions for the child. Is that correct?
Yes, sir.
Do you believe that that would be in the child's best interest at this stage of her life?
Yes, sir.
And with regards to, you're not asking for any sort of child support be ordered. Is that correct?
No.
You're willing to take on the responsibility of raising the child
yes,
financially and otherwise, correct?
Yes, sir.
And as far as any visitations to be imposed for Mr. Ruben Alvarado, you asked that no visitations be imposed at this point due to the fact that he hasn't been a part of the child's life. Is that correct?
Yes, sir.
Okay. And you're asking the court to approve your request today, correct?
Yes, sir.
And I explained to you the difference about what we're doing here today and a termination of rights and an adoption. Is that correct?
Yes, sir.
And however, at this stage, you have decided to proceed with obtaining the rights first, correct?
Yes, sir.
I pass the witness, Your Honor.
Okay, Mr. Bravo, do you have any questions?
Just briefly. Ma'am, as far as you haven't had any contact with Mr. Alvarado since the child was 2 months old?
Yes, sir.
That was over 10 years, been over 10 years?
Yes.
Do you have any, did you know of any family members of his?
No, I don't. We didn't know nobody from his family because when my sister, because he didn't have papers, so when he came over here, he was with my sister, and I lent them a trailer that I have here next to my house. So they were living there, and she was pregnant. And then she had my niece, and after 2 months, they got in a fight, and he just left. So I don't know if my sister saw him again, or if he saw if my sister would let him see the baby. I don't know nothing about that because, how I told Mr. Flores, my sister wouldn't tell us anything. He wouldn't tell me or my family anything about it. They just got in a fight and he just left.
Thank you, ma'am. No further questions, Your Honor.
Okay. Anything else, Mr. Flores?
Nothing further, Your Honor.
Okay. Given the circumstances and in reviewing the pleadings, the court is granting, let me see. The court is granting Ms. Barbosa's suit affecting the parent-child relationship as to the minor. The court is further finding that she has standing to bring the suit because she's had actual care, control, and possession of the child for at least 6 months and not more than the 90 days preceding the date of the filing of her petition as per the Texas Family Code. Is there an order on file?
If there's not, Your Honor, I can have one submitted this afternoon, Judge.
Okay, let me check. No, sir, there's no order on file, but if you can get that with the signatures of Mr. Bravo and your client, I'll just set a tickler for February the 11th.
Very well, Judge.
Okay. Ms. Barbosa, I'm very sorry for the loss that your family has suffered due to this virus. And I commend you for stepping up to honor the memory of your sister with your niece. And I'm sure that your niece also appreciates everything that you have done and will do for her in the future. I wish you the best of luck and may God bless you.
Thank you.
Thank you.
Right. Yes, you may be excused.
Thank you, Judge.
Okay, anything else, Mr. Flores?
Nothing further, Your Honor.
All right, Mr. Bravo, have your fees been taken care of or have y'all come to an agreement?
Judge, I've already made contact with Mr. Flores and they've already been arranged.
All right. Okay. All right. Well, thank you. Y'all have a good day.
Thank you, Judge.
All right, Mr. Ramirez?
Good morning, Your Honor. Number 30 on this court's docket.
Good morning, sir. All right, CL 23089-I, Montrell Rand et al. Versus Ofelia Luna.
Ruben R. Ramirez on behalf of the defendant, Your Honor.
Good morning, Your Honor. David Solis on behalf of Mr. Rand and Ms. Cruz.
Okay, and what is the announcement?
This is a status hearing, Judge. We just need a trial date. I will inform the court that not Mr. Rand, but the other passenger has settled. We should be getting the partial dismissal documents to the court within the next 30 days. So we just need a trial date for Mr. Rand's portion of this claim.
That is correct, Your Honor.
We've already mediated the case and we've already done depositions of the parties.
Okay. All right, then file a motion for a DCC and we'll give you those deadlines and the trial date. And I'll set a tickler for Ms. Luna's settlement documents for March the 4th.
That should be more than enough time, Your Honor. I don't have any other business before this court. May be excused.
Yes, sir.
The same, Your Honor.
Okay, thank you, gentlemen.
Okay, thank you. God bless y'all. Take care.
Thank you. Likewise, y'all have a good day.
Thank you.
Okay, Ms. Thompson?
Yes, Your Honor.
Okay, do you have, I know you have something on the 11 o'clock.
Oh, I'm
no,
so
that's
sorry,
not
Judge.
you.
I must have logged in early. It's on number 37. If it's 11, then I'll just log back in.
No, I'm wrong. I'm thinking about you on Friday.
Oh, yes, that's another one.
F 5108-16-9 in the interest of a minor child.
Yes, Your Honor. Kevin Rodriguez is here, and I don't see the ad litem, Kathy Alvarado. And I also don't see Andrea, the mother of the child.
Your Honor, this is Andrea Trevino here, ready
There
for
she is.
court, pro se.
Okay.
Okay, let me see. Well, it's a status. Do you want to go ahead and update the court?
Yes, Judge. The parties have been doing the standard possession order, and I haven't heard much in the way of anything different or needing to change. I don't know if the court wants to set it for a final or if the court would like to continue as status for a future date. I'm open to whatever the court says.
Okay, are you, ma'am, are you ready to proceed for a final hearing? Are you going to be staying with the current orders for right now?
No, Your Honor, I was not in agreement with the current orders that are temporary for Dad.
Okay, so then I think the last time you stated that you might be hiring counsel. Have you already done that?
No, Your Honor, I still have not hired anybody as far as right now. I was still gonna look into it to see if I could hire somebody, but at this moment, no, I have not.
Okay, so it sounds to me that you'll be needing a contested hearing, ma'am. So you will need to be getting your counsel as soon as possible so that that person can start communicating with Ms. Thompson and work this up for a final hearing, whether it be a contested final hearing, whether it be something for a bench trial or a trial setting, a jury trial setting. But you can't be just waiting to see like, okay, am I gonna get it this week? You need to do something fast because we need to get you set. So Ms. Thompson, I'm hearing that it's going to be contested. You have an order in place right now. So of course that will be, that will stay. And you'll continue abiding by that order until something happens. And so what we'll do then is the only thing that I can do at this point is set it for another status, which I don't think is really fruitful since you're just going to be going ahead and continuing with this unless she hires somebody. But
I was going to suggest, Judge, could we wait and see if she hires somebody and then go forward then, because then I'd know what to announce to the court.
Yes. So what I'm going to do just for myself is I'm going to set a tickler to look into this case for March the 25th. And if nothing has been done by that point, then we'll set you for something so that we can continue to proceed, because I know you just can't be waiting and lingering and working on temp orders.
Yes, ma'am.
Okay. So it'll be, I'll set a tickler for March the 25th just to see if something has happened by then.
Perfect. Thank you, Judge. May we be excused?
Yes, y'all may be excused.
Thank you.
Thank
okay,
you.
Bye-bye.
Okay, thank you. All right, Mr. Ortiz.
Good morning, Judge.
Good morning.
I've got number 14 on the docket. I believe my client is on. Gustavo Guardiola, I believe is on.
Okay, it's CL 21-3496-I. Encore Fine Properties et al. Versus Luciadira, Lucyadira Castanon, Castanon. And Mr. Guardiola, can you hear me?
Yes, Your Honor.
Okay. And Mr. Ortiz, you're ready to proceed on a default judgment?
I am, Your Honor.
Okay. Do you need your client sworn in?
Yes, please.
All right, Mr. Guardiola, will you please raise your right hand? Do you swear that the testimony that you are about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you may lower your hand. Mr. Ortiz, you may proceed.
Thank you, Honor. Would you state your name for the record?
Yes, my name is Pedro Gustavo Guardiola.
And you work for, you're a real estate agent, correct?
That is correct.
And your broker is Encore Properties, correct?
Correct.
Okay, and you and Encore have filed suit in this cause number against the defendant for her failure to pay your commission, correct?
Correct.
All right, and on October 13th is actually when we filed this lawsuit, October 13th of 2021, correct?
Correct.
All right, and Your Honor, for the record, I want the record to reflect that citation has been returned, been on file for at least 10 days. Her answer date was December 6, 2021, to which she never answered.
Okay.
And Mr. Guardiola, as the agent, you had the property sold that's located in 1911 Lago Huron in Edinburgh, correct?
Correct.
And your agreement with the defendant was that you were going to collect 6% of the sales price, which totaled $22,800, right?
Correct, yes.
Right. In addition, because she did not answer your phone calls, she did not appear at the closing, and you have lost the commission of $22,800 plus attorney's fees, correct?
Correct, yes.
All right. And the attorney's fees to date in trying to locate her and find her and draft letters and petitions is $5,000, correct?
Yes.
All right. And you're asking this court to award you $27,800, correct?
Correct.
Okay. And Your Honor, that's all we have. I have submitted a proposed default judgment to the court, and that's all we have today.
Okay, let me see. Okay, the court is granting the plaintiff's default judgment. It's taking judicial notice of the documents in the court's file, specifically that service was perfected and return has been on file for the required amount of time, and is also granting the relief requested by defendant. I'll ask for the order that you filed on December 20th, 2021 to be forwarded to my queue, and then I'll sign off on it, sir.
All right. Thank you very much, Your Honor.
Okay, thank you. Y'all have a good day.
Okay. You too. Thank you.
Thank you.
Yes.
Bye.
Okay, Ms. Paredo, can you hear me?
Good morning, Judge.
Good morning.
Paloma Barreiro, I have a divorce today with, the case number is F2356219. I'm here on behalf of petitioner Brenda Ibarra, and she is present in my office.
Okay, and is the respondent present as well?
Judge, this is an uncontested divorce. He filed a waiver of service, and I submitted the signed decree this morning.
And it has his signature as well?
Yes, Judge.
All right. Okay, Ms. Ibarra, please raise your right hand.
And Judge, she does need the services of an interpreter. Sorry.
Okay, so when whatever you're gonna need interpreted, just make sure that you go slow so that Ms. Castañeda will be able to do that.
Yes, Judge.
All right. Okay, so Ms. Ibarra, please raise your right hand. Ms. Castañeda?
Ms. Ibarra, por favor, levanta su mano derecha.
Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Jura que el testimonio que está a punto de dar es la verdad, toda la verdad y nada más que la verdad. Sí. Yes.
Okay, you may lower your hand.
¿Puede bajar su mano?
All right, Ms. Barredo, you may proceed.
Thank you, Judge. Ms. Ibarra, can you please state your full name for the record?
Brenda Yadira.
Espera para la persona traducir. Y luego ella te va a preguntar. Okay, Judge, sorry.
All right, go ahead. So, have her state her full name for the record.
Ms. Ibarra, por favor, diga su nombre completo.
Brenda Yadira Ibarra.
Brenda Yadira Ibarra. Okay, and before filing your petition for divorce,
You've lived in Hidalgo County at least 90 days and in the state of Texas for at least 6 months. Is that correct?
Antes de meter su petición, Miss Ibarra, usted vivía en el condado de Hidalgo por los presidentes por los presidentes 60 días y en el estado de Texas por los presidentes 90 días.
Sí.
Yes, sí, yes.
And you married Juan Carlos Ibarra on or about November of 1992 and separated from him on or about March of 2021. Is that correct?
Y usted se casó con el señor Juan Carlos Ibarra como en noviembre. Can you repeat the date, ma'am, please?
November 1992 and separated March 2021.
En noviembre del 1992 y se separaron como en marzo del 2021.
Sí.
Yes.
And is there any chance of reconciliation with Mr. Ibarra?
¿Hay alguna posibilidad de reconciliación con el señor Ibarra?
No.
No.
And there was one child born from this marriage who's under 18 and her name is Yaris Ibarra. Is that correct?
Hubo una niña nacida de este matrimonio de nombre Yaris Ibarra, ¿es correcto?
Sí.
Yes.
And it's the agreement of the parties that you will remain with primary custody and Mr. Ibarra will have the standard family code visitations, is correct?
Y es el acuerdo que usted se va a quedar con la custodia primaria.
Sí.
Yes.
And with regards to child support, it's the agreement of the parties that Mr. Ibarra will pay you $1,000 a month for child support. Is that correct?
Y en la custodia de la manutención, el señor Ibarra le va a pagar $1,000, ¿correcto?
Sí.
Yes.
And are you currently expecting a child with Mr. Ibarra or anyone else?
Y en este tiempo está usted esperando bebé con el señor Ibarra o cualquier otra persona?
No.
No.
And with regards to community property, the parties have agreed that Mr. Ibarra will stay with the land located on Goodwin Road. Is that correct?
Y tocante con la propiedad de la comunidad, ¿están de acuerdo que el señor se va a quedar con la tierra que está en Goodwin Road, correcto?
Sí.
Yes.
And he will remain with all of the vehicles in his possession. Is that correct?
Y él se va a quedar con los carros que tenga en su posesión, ¿correcto?
Sí.
Yes.
And you will remain with the house located at 802 Pammy Circle in Palmview. Is that correct?
Y usted se va a quedar con la casa que está en 802 Tammy Circle, ¿correcto?
Sí.
Sí, yes.
And it's further the agreement of the parties that to equally distribute the community estate, he's going to pay you the sum of $33,000 to be paid within 24 months in a monthly payments of $1,375. Is that correct?
Y en la división de la propiedad, él le va a pagar $33,000 en 24 pagos de $1,375, ¿correcto?
Sí.
Yes.
And it's further agreed by the parties that there will be no harmful contact, harassment, or threats between you two. Correct?
Y también están de acuerdo que no va a haber ningún contacto dañino ni
harassment or threats.
Acoso o cualquier otro amenazas, ¿correcto?
Sí.
Yes.
Okay. And you'll remain with all the personal belongings in your possession, and he will remain with his personal belongings. Is that correct?
Y usted se va a quedar con todas sus pertenencias personales y él se va a quedar con todas sus pertenencias personales, ¿correcto?
Sí.
Yes.
And retirement, if any, he will stay with his retirement and you will stay with your own retirement. Is that correct?
Cualquier jubilación, él se va a quedar con su jubilación y usted se va a quedar con su jubilación, ¿correcto?
Sí.
Yes.
And with regards to debt, you'll be liable for any debt under your name and he will be liable for any debt under his name. Is that correct?
En tocante las deudas, usted se va a quedar con las deudas que pertenecen a usted y él se va a quedar con las deudas que pertenecen a él, ¿correcto?
Sí.
Yes.
And you're also asking for a name change. Is that correct? You want it to be changed from Brenda Yadira Ibarra to Brenda Yadira Garcia. Is that correct?
Y también está pidiendo un cambio de nombre de Brenda
Yadira Ibarra.
Ibarra a Brenda Yadira García, ¿correcto?
Sí.
Yes.
Okay. And you're asking the judge to grant your divorce today, correct?
Y usted le está pidiendo a la corte que le otorgue el divorcio, ¿correcto?
Sí.
Yes.
Judge, I have no further questions. At this time, we respectfully ask the court to grant the parties divorce.
Okay, so that child support is supposed to start on February the 1st, 2022. Is that correct?
Yes, Judge.
Okay, and what type of medical insurance does the child have?
Judge, the medical insurance is she's gonna be the person to provide it on her own with the child support payments that she gets.
Okay, so the child's not on Medicaid.
No.
Okay, perfect. Okay, the court is going to take judicial notice of all the documents in the court's file, specifically the waiver of service filed by Mr. Ibarra, and is granting the relief as requested by the petitioner in this matter. The court is granting her name change to Brenda Yadira Garcia, and also is taking judicial notice that the final divorce decree that is on file with the court does mirror the testimony that the petitioner has put on the record today and has also been signed by the respondent Juan Ibarra. So I'll ask for that decree that was filed today to be forwarded to my queue, and I'll sign off on it, Ms. Paredo.
Okay, thank you, Judge. That's all I have. May we be excused?
You certainly may. Thank you so much.
Have a good day.
Likewise. Okay, Mr. Contreras?
You are number 6 on your docket. Good morning, Judge. Good morning. Number 6 on your docket. It's just an agreed divorce, Your Honor. The parties have signed off on the divorce. I just need to prove it up, Your Honor.
All right, that's F1933-20-9 in the matter of the marriage of Jose Gomez and Sandra Gomez. Is Mr. Gomez present?
Yes, he is, Your Honor. I believe so.
Jose Gomez, can you hear me? Jose Gomez. I don't have anybody on by that name.
Your Honor, can I submit just to an affidavit and proving up the divorce? We submitted the agreed final decree of divorce signed by all parties, but I can submit a statement as well notarized by, and this way we can eliminate the necessity of resetting the case, Your Honor, and I'll submit it this afternoon or this morning, actually. Should have been present.
Did you say that you have a divorce decree on file? Because I don't see one on file.
Should have been filed. You don't see it, Judge?
No, sir.
Okay, I have it here in front of me. I'll submit it right now, Your Honor. And with your permission, I can submit a prove up affidavit as well.
And that doesn't have his, and does that have both of their signatures on it, the divorce decree?
Yes, it does, Your Honor. And there's no kids, there's no property other than
That's fine.
ones.
Okay, I did see the petition. There are no children. There is no property between the parties. So I'll go ahead and allow you to submit that divorce decree and the affidavit as you stated. And I'll give you, I'll go ahead and set a tickler for February the 18th, just to make sure that it's already been done.
Yes, Your Honor. And I'll file it before 12 or a little bit after, Your Honor. Thank you so much.
All right, thank you.
Thank you. Thank you.
Yes.
Have a good week.
Likewise. Okay, Mr. Rodriguez?
Yes, good morning, Your Honor.
Good morning. What number, sir?
I'm here on a case CL-19-3806-1.
Do you know what number that is on the court's docket?
Judge, did he say 4619?
I don't know, Mr. Oh, we lost him.
Oh, no, I see him, Judge.
Oh, where? Mr. Rodriguez,
Yes,
can you give me that case number again? I'm sorry.
yeah, it's 19-3806-I.
Okay, 19-3806.
Number 31, Your Honor.
Okay,
Your Honor, Jack Skaggs, I'm here on behalf of Miguel Esparza on that case, number 31 on your docket.
okay. All right, and what is the announcement?
Well, this was it said for status. We were waiting for the defendant to retain counsel, but I believe they already have. So we just need a hearing for final hearing, a day for a final hearing, and maybe in the meantime we may see if we can reach an agreement.
Okay, Mr. Skaggs?
Your Honor, I just filed an answer last week, and I would probably need about 90 days to conduct some limited discovery. And I believe there's a pending motion for summary judgment, and we'll see if we can try to get the necessary discovery to respond to the motion within the 90-day period.
Okay, let's come back on April the 25th at 9:30 for a status to see how far you've come. And are you urging I see that there's a motion to oh no, the defendant is to retain counsel. Okay, never mind, I misread that. All right, so let's come back on April the 25th at 9:30 to see how far you've gotten. And I'll give you the opportunity to start working up the case.
Okay.
All right, anything else?
No, Your Honor.
Oh, I'm sorry. Nothing else on this case, but I have another case.
Okay, Mr. Skaggs, any other case?
No, ma'am, Your Honor. May I be excused?
Yes, sir. Thank you. You have a good day.
Thank you.
Okay, Mr. Rodriguez, your next case?
Yes, Your Honor, the next case is CL 21-0889.
Okay, that's number 18 on the court's docket, Bank of America versus Daniel Vasquez. And what is the announcement, Counselor?
Your Honor, we're hearing a motion for substitute service. We have filed the motion with the affidavit of the server of Procer, but it's indicated that he had made several attempts to serve the person, but couldn't be found. So we're asking the court to grant this motion so that the defendant can be served by leaving a copy with any person older than 60 years, or by affixing it to the front entrance of the residence that we have on file.
Okay, I do see the affidavit and the motion that is on file. And the court will grant your motion for substitution of service, and I'll ask for the order that was filed on December the 29th, 2021 to be forwarded to my queue.
Your Honor.
Very well.
Yes.
Just for clarity, Your Honor, the defendant did call in to the staff judge with hearing court 8 and court 9, and they did provide an email, and the link for today's hearing was provided for the email to that email for the defendant, and it was Vasquez dv33@yahoo.com.
Okay, is there a Daniel Vasquez present?
Yes, I am. I'm here, ma'am.
Okay,
Good
sir.
morning.
All right, good morning. Okay, so then, are you going to be representing yourself, sir?
Yes, ma'am.
Okay, so do you, I'm assuming you would want a copy of the petition that has been filed against you?
Yes, ma'am. I already made arrangements prior to the court date, and that I was supposed to already start making payments. I'm just waiting for my ATM card to come in because I had COVID, then I lost my card when I got some medication. But I told them I would make the payment by the end of the month, and I already made arrangements with them. And I also received something from them also some signatures I need to send back to Coach and Lambert.
Okay, and what is your email address?
It was VasquezDV33 at Yahoo.
Okay. So it looks like, Mr. Rodriguez, that there's already been an agreement that Mr. Vasquez and the plaintiff have entered into. So I'm assuming there's going to be an agreed order that will be filed.
Yeah, I wasn't aware because I'm just representing the plaintiff as local counsel, but normally that's what happens. So we can just reset it for a status within, I don't know, 60 days maybe.
Okay, what I'll do is I will set it for a status hearing for March the 21st at 9:30 to see if the agreed order has been filed by that time.
Okay, thank you,
Very
Judge.
well.
Okay?
And that was March the 21st?
Yes, at 9:30.
Very well. Well, that was my last case in this honorable court, Your Honor, this morning. May I be excused?
You certainly may.
Thank you,
Thank
Judge.
you.
Can I
Have
be
a
excused?
beautiful rest of the day.
Thank you, likewise. Mr. Vasquez, if nothing further, you're also excused.
Thank you, Judge. Take care.
Thank you, likewise. Okay, Mr. Jackson? You're on mute, Mr. Jackson.
Hi, can you hear me, Judge?
I certainly can, sir.
Great. Judge, we have an uncontested divorce. I don't know if Ms. Olivares is on, but we were added on at the last minute. We're number 42 in the court's docket.
She's not on, and I understood that was the AG's office also going to be present?
Yes, Your Honor, and I don't think they're there. So what we can do is just, I guess we can submit a signed decree and the court can set us for a week or sometime later on, and next week, and we can just prove it up.
Okay, well, do you want to, I know you got on early. Do you want to wait just a little bit to see if Ms. Trevino comes back on?
Well, I really do have an urgent errand to attend to, Your Honor.
Okay.
If we can just get a week reset, I would be more than happy with that.
And you all have already, so you all have already agreed to the terms?
Yes, everything is in the decree. She sent it to me. I reviewed it with my client, Mr. Jose Adriel Tapia, who is on, and we don't have any problems with the terms and conditions of the decree.
Okay. Then, and so then it'll just be, you just want to reset it for a quick prove up then?
Exactly. Just won't take 5 minutes of the court's time.
Okay. All right, then we'll go ahead and squeeze you in on January the 31st at 9:30.
Okay, Judge, thank you so much. It's always a pleasure being before this honorable court, Judge. May I be excused?
Yes.
Thank you, Judge. Good seeing you.
Thank you. Likewise. Take care.
Bye-bye.
All right, Ms. Guerra.
Good morning, Your Honor. I have a fairly straightforward motion before the court on number 19 on the court's docket.
Okay.
And I believe Mr. Mount, opposing counsel, is also on.
All right, CL 153318-I and Alyssa Rodriguez versus Alejandrina Gutierrez Perez et al.
Your Honor, this is a case that has been severed into multiple different cases. And my case is Alyssa Rodriguez versus Geico Insurance, and I represent Geico in this matter. Ms. Rodriguez was in an auto accident with a Geico insured, Ms. Gutierrez Perez. That case had gone on to appeal, but has now come back. From the 13th, saying that it had, I believe, fact issues and would need to be tried. It's an auto accident case, Judge. It is Geico's position that any action which Ms. Rodriguez might have against Geico cannot be decided until a jury decides whether or not Ms. Gutierrez was actually at fault in her wreck with Ms. Rodriguez. These claims come out of Geico paid property damage to the lien holder of Ms. Rodriguez's car. Nissan and Ms. Rodriguez believes our payment of the lien was improper. But if Ms. Gutierrez isn't even at fault for the wreck and a jury doesn't make any award of damages, then there would be no claim at all against Geico because Geico would need to pay Ms. Rodriguez's property damage. So until that tort case, which is also in your court, between Ms. Rodriguez and Ms. Gutierrez is resolved, there can be no case against Geico.
Okay.
So we are moving to abate it.
Okay. Mr. Mount? Oh, you're on mute, Mr. Mount.
Your Honor, William Mount for the plaintiff, Alyssa Rodriguez. We are opposed to this motion. Number one, this court had ordered us to mediation, I believe, in September, and we conducted mediation in November. So one of the arguments we're making is waiver. They've waived this claim or this motion for abatement. That's the first argument we're making. The second argument we're making is that Geico has the burden of proof on this particular motion. In other words, they have to prove by a preponderance of the evidence that this case should be abated, and we've provided case law from Corpus Christi for that particular proposition. Geico has provided no case law to support their position for an abatement of this particular case. The only two authorities that Geico provided were cases involving their insurance companies where their own insured was suing for breach of contract and also for extra contractual claims. This is not a breach of contract case, and we're not suing for extra contractual claims. Geico was never our insurance company. What we're suing Geico for is tortious interference with a contract that my client had with Nissan Motor Corporation. It's our position that that contract was interfered with, and so my client has certain damages arising from that particular interference. And those damages include mental anguish damages, injury to credit, reputation damages, loss of use damages. So this particular lawsuit really has nothing to do with my client's claim in the auto accident case against Ms. Gutierrez Perez. When you look at the authorities that were cited by Geico, they cited Texas Farmers Insurance Company and also Mid-Century Insurance Company. In both of those cases, the courts said that they were looking at a very narrow issue. And the very narrow issue was whether a trial court must, upon request, sever and abate a bad faith claim from a breach of contract claim when the bad faith claim is based entirely upon the settlement offers tendered by the defendant. We don't have that fact scenario in this case. There's no issue. There's no first party claim against Geico that's being brought. There are no extra contractual claims being brought. Settlement offers aren't in dispute in this case. So for those reasons, Geico has brought forth no evidence to this court or authority to support an abatement, and we would ask that the court deny the motion for abatement.
Okay.
Your Honor, if I may briefly respond.
Okay, before you do that, the thing is that, I mean, obviously this is a very long docket sheet. And so have you all taken up this motion before?
Yes, Your Honor, the case was previously abated when it was in County Court 2. And then when the Rodriguez versus Gutierrez case went on appeal, then this case was revived. And it's our position that now, since there is no longer a Rodriguez versus Gutierrez appeal, that our case should be abated again.
The plaintiff disagrees with Ms. Guerra's position on that. Ms. Guerra had filed a motion to sever originally for Geico, and the severance was granted, but in her order, she put language abating the case also, which was not a subject of her motion or the subject of the hearing. The prior judge did sign that particular order, and the case was abated, but the abatement was lifted by this court in June of this year by agreement of the parties. It was unopposed by Ms. Guerra at that time.
Okay, and that's where my confusion is, or is the way that I'm seeing it, because I'm looking back and I saw the motion for severance that was filed back in
Probably 2019, even
no,
earlier.
well, the one that I saw, I think, was 2017,
Okay.
maybe. And the order of the language, the language in that order wasn't what was pled in the motion. And or not, or maybe I mean, unless I read it wrong, but then I didn't see a motion specifically for abatement. So now you're re-urging that original motion, or because I don't see anything else unless I'm missing it somewhere.
When I did the original motion to sever, I can't recall if the language for abatement was in it. I assume it was, because most of my motions would have included a motion to sever and abate simultaneously. And the court granted an order which was to sever and abate. So the case no longer needs to be severed because it's already been severed. So
Right.
this time I only refiled it as a motion to abate.
Your Honor, the original motion was titled motion to sever. There was no request for an abatement in there. And then the order that ended up being signed said that the extra contractual claims were being abated. There was language like that in the order, but there are no extra contractual claims in this lawsuit.
Okay, hold on. Okay, got it. Hold on. Okay, no, Ms. Guerra, I apologize. I was looking in the wrong case file. I was looking in the original case file, not in the one that was to this. So yes, your motion for abatement was filed on November the 23rd. Okay.
Yes, in this case, yes. Judge.
Right. Okay, so is there anything else that you all want me to consider before I issue a ruling?
Only the additional fact as it goes to waiver, Your Honor, that in the interim of us lifting the original abatement and beginning to proceed last summer, the case came back down on the auto accident case from the 13th Court of Appeals. So we don't believe there was any waiver due to the fact that the circumstances changed in what we thought was a resolved issue on the case. We would have just proceeded with our earlier summary judgment that we had first filed in County Court 2, but we were ordered to mediation before we had any substantive hearing. So we tried to mediate and that was unsuccessful. Okay. That's when we learned that the case was back down from the 13th as to the auto wreck, and then we filed the motion to abate.
Okay, got it. All right, so do you have competing orders on file? I see the order denying, but I don't see the order granting.
Your Honor, if we don't, I'll get one on file today.
Okay.
And I would like to address the waiver issue. The case did come back, and it came back July 1 of last year. And so this court, your honorable, you ordered the mediation, I believe, in September, and it occurred in November, as I indicated earlier. So Geico was aware at the time of the mediation and at the time of your order that the case had come back, the auto accident case.
Since we're not a party to that suit, Your Honor, we weren't aware that.
Okay. All right. Well, then I'll go ahead and I'm taking this under advisement. I've listened to all of your arguments, and then I'm going to read your orders, and I'm going to reread the motion for abatement since I was not looking at the right one. I apologize for that, but I will look at it. Okay. So then we'll go ahead and then I'm going to go ahead and just set this for a status hearing, which is going to be on March the 20th.
I'm sorry, Your Honor, to interrupt you. We do have a status date currently on this case on the 16th of February. If you'd like, Judge, we can keep that one or we can remove it, Your Honor.
No, we'll keep it. we'll keep it so I can make myself issue a ruling before then. Okay?
Thank you,
All right.
Judge.
Have another, when's our next status hearing then, Judge? The
I believe
16th?
you're set for February the 16th at 9:30. That should already be on your calendar.
Right. Thank you, Judge. I have no further business with the court. May I be excused?
Yes, thank
Thank
you.
you, Judge.
Yes, may we be excused. Thank you.
You certainly may. All right.
Judge, can I address the court?
There you are. I was looking for you. Yes.
It's Fellow Olivares, Your Honor. I'm in a contested hearing with 370th, but my client really wants to go forward. Is there any chance you can call it a little later or after lunch, Your Honor? I'm almost through over here.
Well, I just need the AG's office on because Mr. Jackson made an announcement stating that they were in agreement with the proposed order that you sent over.
Okay.
But I don't
okay.
have the AG's office that's checked in on this case.
All right. Can I get them to, it's 11:20 already, Judge. Should I call them and see if they can log in about 11:45? I think maybe I'll be through over there or after lunch, however the court wants.
You can check in with us before noon at about 11:45. I still have some attorneys that are on here, so we'll probably still be on.
Okay.
And then let's see where we're at that point.
Thank you, Your Honor, so much. Thank you.
Okay, you're
I'll
welcome.
be back.
Thank you. Okay, so any other quick announcements before I just start calling the attorneys as I see them because it looks. Okay, Mr. Palacios.
Good morning, Judge. I have number 22 on your civil docket.
All right, F 4422-19-9, Jeanette Garcia versus Toby Garcia.
Good morning, Judge Sunny Palacios, Mr. Garcia. So in this case, all we're asking the court to do is consolidate this case with the, let me see, F 444321B. The case has already been transferred over from Judge Kenneth Flores. It was filed by the OAGs, but it's the same child support issues that are in the divorce case.
Okay, can you give me that cost number again, please?
Yes, Judge, F 444321B.
Okay. All right, and is there anybody on the other side?
Judge, I didn't see.
Does Mr. Garcia, is he representing himself?
He is not, Judge, but we did have the hearing with Mr. Vasquez, Mr. Flores, Judge Flores, and he wasn't opposed to the transfer. Okay. He's not going to be opposed to consolidations, obviously.
Okay, then the court is granting your motion to consolidate. Do you have an order on file?
We have a file, should be there, Judge.
Okay, so then I'll ask for that order to be forwarded.
Thank you, Judge. I have nothing further before it's honorable court, Judge. May I be excused?
Yes, you certainly may.
You have a wonderful day.
Okay, thank you. Ms. Padilla?
Good morning, Your Honor. I'm here actually on two cases. The first one is number 15 on the court's docket.
Okay, CL 170613-I, Angel Garcia et al. Versus Jesus de la Rosa et al.
I'm here from Padilla Law Firm for co-plaintiffs Ruben Hernandez, Roberto Palacios, Gilbert Guerin, Antonio Montales, Marta Mancia, individually and as an ex-friend of the minor. In this case, I believe co-plaintiffs Angel Garcia and Karina Solis, represented by Ezekiel Reyna's office, filed a motion for default judgments. I do not believe anyone is here on that, but I did want to make an appearance before the court.
Okay, yes, nobody has checked in on that, so we won't take up that motion for default judgment or unless they file an order resetting hearing.
Okay. Well, then the next case that I'm here for is number 34 in the court's docket.
CL 191967-I, Juanita Garcia versus Penske Truck Leasing et al.
And I believe that.
Yes, sorry, Luis Del Villar for Penske and Miguel Reyes, Your Honor.
Okay. And what is the announcement, counselors?
We're doing a minor settlement hearing?
Okay, so for this, what do you have as far as status is concerned? Have you all settled the matter already?
Yes, ma'am.
Yes, Your Honor.
Okay, so then do you need an opportunity to have those settlement documents circulated for signature?
I don't think so, Your Honor. I think we're just ready to go ahead with the hearing.
So you all have already, but do you have an agreed order?
I do believe that we are in the works of getting a final judgment signed and filed with the courts.
Okay.
So we would need the opportunity or need additional time after the hearing to file those documents.
Okay, so then are you wanting to put something on the record as to the terms of that agreement?
Yes, Your Honor. There are two minors involved in this case. The father should be on Zoom or checking in as we speak. I did send him a message. He was aware of this date.
Okay, because I have it as a status conference hearing. Are you saying that this is supposed to be a friendly suit? Or what? Because you said there's minors involved, so.
Right. It's my understanding that the defendants are not requesting a friendly suit hearing. However, they are wanting to deposit the settlement for the minors into the registry of the court.
And is there a reason why there wasn't an ad litem requested? Just because there was, I mean, who's looking out for the interest of the minors? I mean, other than, of course, you as the plaintiff's attorney, but is there a reason?
Yeah, yes, Your Honor. My understanding is because the settlement amount to the minors is so small that I mean we're all confident that the father is going to take care of it.
And what is the settlement amount to the minors?
It's $6,000 to Matthew and $5,000 to Adriana.
Okay. Well, we've assigned ad litem attorneys for those amounts, but Ms. Padilla, are you saying that you want to move forward and are comfortable moving forward without ad litems for these children?
That is correct, Your Honor. We do feel comfortable that there is not an ad litem required unless the court says otherwise.
All right, so then, and who is the parent that you're needing to testify on your, to prove up the agreement?
It is Mr. Jose Garcia.
Okay, Jose Garcia, are you present? Jose Garcia? I don't see anybody on by that name.
He may be just logging on now. Perhaps he's in the court's waiting room.
I don't have anybody in the waiting room though.
I'll
give it, why don't I go ahead and call the next case, and then if he comes in, because there's nobody on here right now, but if he comes in, I'll go ahead and let you know, and that way I'll recall the case.
Thank you, Your Honor.
Okay.
Your Honor.
Okay, Mr. Ramirez, Attorney Dennis Ramirez.
Your Honor, good morning.
Good morning, sir.
I have a family law case with the court this morning. This is going to be on number 38 on your docket.
Okay, F 4436-21-9 in the interest of a minor child.
Yes, Judge. Dennis Ramirez on behalf of Ana Gonzalez. I believe she's in the waiting room. Mr. Jaime Cavazos is opposing counsel on this case.
Good morning,
Okay.
Judge. Jaime Cavazos here for Mr. Garcia. He should also be on Zoom, Judge.
Okay, so you said Ana Gonzalez?
Yes, Judge.
Okay, is there an Ana Gonzalez present? Ana Gonzalez. I don't have anybody on by that name. I do have a Galaxy A12. That's the only one that doesn't have a name. And Mr. Cavazos, what's your client's name?
Yes, Judge. Joel Garcia, Judge. He is.
Okay, Mr. Garcia is present on Zoom.
Okay, Judge, I had touched base with her at 9:30 or before to make sure she was going to log on. If the court could recall it briefly, let me make sure she's on.
I sure will.
Thank you, Judge.
Okay.
Thank you, Judge.
All right, Attorney Memo Tejerina.
Hi, Judge. Good morning. I'm number 17 on your docket. I'm here with Mr. Clark. I represent Jackson Wright.
Good morning, Your Honor. Jared Clark on behalf of the plaintiffs, Deandra Vargas and Maria Vargas.
Okay, CL 20-2580-I. And what is the announcement?
Judge, this was a hearing on my motion for protection and motion to stay proceedings. This is a case where my client is serving in the U.S. Navy. He's stationed out in California. I provided an affidavit that I received, the Civil Service Member Civil Relief Act. My team went out and went ahead and got that affidavit, submitted it to the court. It shows that he is on active duty status. The last I had spoken to my client, it looked like that service ran through 2025. At the time that I had spoken to my client, he was in, so I guess he got through boot camp and then was, I guess, going to specialized training, at which point, I guess, to do whatever job he was going to do in the Navy. And I make some of these comments, Judge, but unfortunately, I understand that he has switched cell phone numbers. And so, I just haven't had communication with him. I'm trying to reach out. I wish I had gotten the information about what base he was located on in California. I don't have that information right now, Judge. And so that's why I'm asking the court to protect us from discovery and to stay the proceedings. I cited to the Civil Service Members Relief Act in terms of where this is coming from.
Okay, Mr. Clark.
Thank you, Your Honor. So I uploaded a response to the motion around, I want to say around 8:30, 9 o'clock. And basically what I'm emphasizing in my response is the case law that makes it clear that while the Civil Service Civil Relief, the Service Members Civil Relief Act should be liberally construed to accomplish its purposes, the statute should not be used as a device to delay the proper and expeditious determination of legal proceedings when the rights of the party in the military service will not be materially affected thereby. In other words, it's not enough to say that my client is in the military in order to get the stay that you're requesting under that statute. You need to be able to show two different basically documentary pieces of evidence in order to show that your ability to participate in the litigation is materially affected by your presence in the military. The first that the statute requires is a letter from the service member. It's actually kind of vague, but it just says a letter that, or some other type of communication that sets forth facts showing that your military status materially affects your ability to participate. And then the second thing, which they have not provided, is a letter from the commanding officer that basically shows that the service member is unavailable for military leave in order to participate in parts of the litigation, like if we need to get a deposition scheduled, or if we need to answer discovery, or do this or do that. They have not provided this court with any sort of letter from the commanding officer of Mr. Wright showing any efforts that he's made at all, whether or not he's entitled to leave, whether or not he's even requested leave from the military. And that's a requirement of the statute. The statute says that any application for stay shall have those two things, and they haven't provided it. And so on that basis alone, Judge, the application for stay and motion for protection should be denied. But I also sort of put in a blurb from the Eastern District of Texas Bankruptcy Court in my response that discusses some of the frustrations that the courts will have when militants apply for these stays. And the court discussed how no evidence has been presented by the debtor regarding his military assignment to Germany and how that relates to the filing and prosecution of this case. No evidence is presented by the debtor that he cannot physically be present in this court within a reasonable time, nor has the debtor shown what attempts, if any, were made by him to address to get leave from his commanding officer. And those are all similar factors here. The defendant's liability insurer has not put forth anything to this court showing that he's even requested leave at all from his commanding officer. They haven't gotten the letter that they're required to get from the commanding officer. And it is required. The statute doesn't seem to make that clear, but in the Texas case law, the courts tease out that both of those items are required. That's Henry Walter. It's a Waco case from 2007, 234 Southwest 3rd, 836, 837. And so bottom line, Judge, in conclusion, State Farm has enjoyed a position of being able to delay this case with our clients because of their client being in the military service. It was very difficult for us to even accomplish service in the first place. Settlement negotiations were, obviously I'm coming from the point of the plaintiffs, but I feel like they were very much in bad faith. And I think a lot of that has to do with the position that they have right now in this case, where they're going to continually try to delay it because of their clients, their status in the military. And I don't think they've complied with the statute. I think that can be seen from the statute itself. They haven't put forth the necessary evidentiary requirements to get the stay and protection they're seeking. And so we're asking the court to deny the stay that they're requesting.
Okay, so Mr. Tejerina, unless you want to respond.
Let me respond real quick, Judge. And let me tell you some of my frustrations with this case, which is that the other side knew. They knew he was in the military. What the insurer did or whatever before the case came to me, that's not my deal, Judge. I don't represent them. But I do find it really interesting that they have a motion for substituted service, a process on the defendant, and they never not once filed the affidavit relating to the Civil Service Members Relief Act. And why would they not provide that to the court? Because they knew he was in the military. And if they knew my client was in the military, maybe the court decides, okay, you know what, we need to find out if this person's available, what the availability is. Instead, what I had to do because of this substituted service, I've had to make attempts to try and get in touch with this person, Judge. And I think it's really important to note that based on what I've represented to the court, based on the motion that I've filed with the evidence showing what his status is in the military, this court has broad discretion to protect litigants from discovery. I'm not saying, Judge, that my client is not going to be available, ever. That's not it at all. But what I am asking this court is for people that are out there fighting for our country, for people that we didn't even give the court notice that they were out there fighting for our country, that I be given the opportunity to work with his schedule, which is what the Service Members Relief Act is designed to do. As it turns out, though, because he no longer lives in the Valley, this accident happened some time ago. It happens. A person changes a number. That's not to say he's not cooperating or anything like that, but it's not the easiest thing tracking down and locating somebody. As soon as I'm able to get in touch with them again, I'd be very glad to talk to his supervising officer and we can get some information to the court. But, when we're talking about the broad discretions under Rule 192, a court can prohibit discovery sought in whole or in part, limit the extent of the subject of discovery, order that discovery not be undertaken at a time or place specified, set the terms or conditions for discovery, order the results of discovery to be sealed or otherwise protected, and make any other order in the interest of justice. And I would just say, Judge, in the interest of justice for those people that are serving this country, maybe the court works with him to try to allow him to answer discovery, when he's able to.
Okay, so this is what we're gonna do since you have not had any communication with your client at this time. What I'm gonna do is I'm gonna hold this hearing over to February the 23rd at 11 a.m. At which time, if you've still not been successful with communicating with your client at that point, then I will make a decision on your motion.
Thank you, Judge.
Okay,
Thank you, Judge. May we be excused?
you certainly may.
Okay.
Thank you. Okay, so Ms. De La Hoya, I see that you've been also patiently waiting and you're pro se. Are you English speaking or Spanish speaking?
English.
Oh, great. Okay, that's F 3322-21-9, number 7 on the court's docket in the matter of the marriage of Elma De La Hoya versus Bernardo Garcia. I have reviewed the divorce decree that is on file with the court. And Ms. De La Hoya, you and your husband do not have any children together. Is that correct?
Correct.
All right, please raise your right hand. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, you may lower your hand. What is your full name?
Elma Nidia De La Hoya.
And have you lived in Hidalgo for at least 90 days and in the state of Texas for at least 6 months?
Yes.
Okay, and you and your husband do not have any children together, is that correct?
Correct.
And are you expecting any children at this time from your husband?
No.
And do you and your husband have any community property together?
We have a house.
Okay. And what is the address of that house?
1124 Model Street in Sullivan City, Texas, 78595.
And who is going to stay with that house?
I am.
Okay. And is that the quitclaim deed that he signed and is attached as Exhibit A to your divorce decree?
Yes.
Okay. Just so you know, just because it's attached to the divorce decree, you also have to have that filed with the deed of records with the county, okay?
Yes, I think it is already.
Okay. And so, and at this time, do you think there's any reasonable expectation for reconciliation? In other words, do you think you and your husband can get back together?
No.
All right. And you're asking the court for a divorce today because your marriage has become insupportable because of discord or conflict of personalities between yourself and your husband. In other words, you all do not get along.
Yes.
Okay. And I do see, do you have any community property debts together?
No.
So any debts that are under your name, you will be responsible for, and any debts that are under his name, he will be responsible for. Is that correct?
Correct.
All right. And your divorce decree, he did sign that decree. Is that correct?
Correct.
Do you have a copy of that decree in front of you?
I have it in my phone.
Okay, but did you have an opportunity to review it?
Yes.
And that is Mr. Garcia's signature. Is that correct?
Correct.
And Mr. Garcia did sign a waiver of service that you filed with this court on August the 11th, 2021. Is that correct?
Yes.
Okay. The court is taking judicial notice of all the documents in the court's file, specifically the waiver of service executed by Mr. Garcia states that we can take this case up. And he has also executed the final decree of divorce. And Ms. De La Hoya, you are not requiring a name change today. Is that correct?
Correct.
All right. Then the divorce decree that you filed on January the 19th, 2022 is going to be forwarded to my queue. As soon as I get it, I will sign off on it. So I'm granting your divorce today and the relief requested that is set forth in further detail in your final decree of divorce.
Okay.
All right. So as soon as I sign it, you'll receive a copy and you will be divorced.
Okay. Thank you.
Thank you.
May I be excused?
Yes. You have a good day, ma'am. Best of luck to you.
Thank you.
All right. Mr. Ramirez, Attorney Dennis Ramirez. Attorney Dennis Ramirez. Okay.
Judge, this is Jaime Cavazos. We're on the other side on the
Yes.
calling.
Yeah, I don't know. I haven't seen, I don't know if his client came on or not. But let me see, Miss Padilla, did your client come on?
Yes, Your Honor. He says that he is logged on.
Okay, under what name?
It might be under Fred Garcia.
Okay, I do see a Fred's iPhone.
Yes, that's me.
Okay. All right, so let me go ahead and recall CL 19-1967-I. And is he the only one that needs to be sworn in?
Yes, Your Honor.
Okay, Mr. Garcia, please raise your right hand. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
All right, you may lower your hand. Go ahead, Ms. Padilla.
All right, Mr. Garcia, can you please state your name for the record?
Jose Alfredo Garcia.
Okay, and you are the father to Audrina and Matthew, correct?
Yes, ma'am.
And your children, Matthew and Audrina, were in an auto accident on April 20th, 2017, correct?
Yes, ma'am.
And as a result of that, a claim was opened on behalf of both children, correct?
Yes.
Okay. And settlements were reached for both of your children, correct?
Yes.
Okay. And a total settlement amount from to be paid by defendants, as you understand it, is $7,000 for Matthew and $2,000 for Audrina. Does that sound correct?
Yes.
Okay. Now, of these amounts, a total amount of $5,183.50 will be going into the registry of the court for Matthew. Is that correct?
Yes.
Okay. And for Audrina, the total amount going into the registry of the courts will be $1,333.33. Is that correct?
Yes.
Okay. And you're asking this, and you believe that these settlements are in your children's best interest. Is that correct?
Yes, ma'am.
Okay. And you're asking the court to approve these settlement amounts, correct?
Yes, ma'am.
Okay. And you understand by asking the court to approve the settlement that if they do, that you cannot come back later and ask the defendants to pay more money, correct?
Right.
Okay. I have no further questions. I pass the witness.
Okay, Mr. Del Villar.
Good afternoon, sir. Let me see. So, sir, have you read and are you familiar with the judgment that's going to be filed in this case?
Yes, settlements are going to be put into like an account for the kids.
Yes.
Once they reach of age, they can withdraw that money themselves.
Yes, sir. And you agree and accept the settlement offers and terms made by Penske Truck Leasing and Miguel Reyes?
Yes.
Right. So you agree to sign the settlement documents releasing the claims you have asserted against Penske and Miguel Reyes?
Yes.
And you're entering into the settlement completely of your own free will?
Yes.
You understand that the settlement is the complete settlement of any disputed claim that your children have against Penske Truck Leasing and Miguel Reyes?
Yes.
You believe that the settlement is fair and in the best interest of your children, Matthew Garcia and Adriana Garcia?
Yeah, Audrina, yes.
Adriana, oh, thank you, sir. Pardon me. Adriana Garcia. So, let's see. Do you understand that defendants, Penske Truck Leasing and Miguel Reyes, are not admitting liability by entering into the settlement?
Yes.
And have you understood all my questions today, sir?
Yes, I have.
Thank you, Your Honor. I pass the witness.
Okay, Ms. Padilla, any other questions from your client?
No, Your Honor.
Okay, the court is approving the agreement as read into the record and testified to by Mr. Garcia and will be set forth in further detail in a final agreed order, which is requiring the attorney's signature as well as Mr. Garcia's signature. So how much time do you need to submit that?
Your Honor, I would say perhaps 30 days.
Okay, I'm going to set a tickler for February the 25th, just to make sure that the order has been submitted.
Thank you, Your Honor.
Thank you, Your Honor.
All right, well, good luck to you, sir.
Thank you
Okay,
so much.
if nothing further, you all are excused.
Thank you, Your
Thank
Honor.
you, Your Honor.
Thank
Have
you.
a good day.
Okay, Mr. Manuel Lopez, what case are you here on, sir? Manuel Lopez? You're on mute, sir.
Yes, so number 24.
Okay, F 4513-09-9, Manuel Lopez versus Laura Monica Lopez.
That is correct.
Okay, and is Mr. Ramos representing you today, Felix Ramos?
No,
Okay, does he represent Miss Laura Lopez?
no, we are both pro se.
Okay. Oh, okay, now I recall you. We're going to file a motion to consolidate because there had been already a previous case. Is that correct?
That is correct.
Okay. So the other case number is F-3756-09-I. Is that correct?
That is correct.
Okay. And you have an order also on file that you filed on October 22nd, 2021. Is that correct?
Yes, correct.
And that's the order that you're asking for the court to sign.
Yes.
Okay. So seeing that those have the same issues with respect to you and Mrs. Lopez, then the court is granting your motion to consolidate. And I'll ask for that order to be sent to my queue and we'll sign off on it.
Okay.
Okay. Did you, let me just double check. Okay, you have both of your email addresses on there. Okay. All right. Thank you, Mr. Lopez.
Yes, Your Honor. What is the next step?
Okay, so since now you have filed a motion to consolidate and that's been granted, then you're going to now, what do you want to do with your case? Like you're going to be moving forward on your petition for divorce, is that correct?
Correct.
Okay. So if you and your wife have come to an agreement, then just file an order setting final hearing and a proposed decree of divorce signed by both of you, and then we can go ahead and get you set and divorced.
Okay.
But I'll go ahead, I'm gonna, so I don't lose track of you since you are pro se, I'll go ahead and set a status for March the 21st, I'm sorry. March 21st at 9:30, it'll be a status. If you have everything in by that time, we can go ahead and divorce you on that day.
Okay, so I need to, can you repeat what I need to do now?
Sure.
I'm sorry.
Okay, so if you and Ms. Lopez have an agreement, then you need to get a proposed, which is a final decree of divorce. That decree of divorce is going
Okay.
to have all the terms of your agreement. And then you and Ms. Lopez will sign off on it. Then you're gonna file an order setting hearing for a final hearing. If you have an order setting hearing for final hearing sent to us, then we will go ahead and put that March 21st date on it.
Okay. And the information for the decree, everything is in file, right? Or,
I can't tell you any more than that because that'll be legal advice, but you'll have to seek out where you'll be getting that divorce decree from.
okay, thank you.
But it'll have all your agreement,
Yes,
okay?
okay,
All right, so we'll
Thank
see
you.
you on March 21st, sir.
okay, thank you.
Okay, thank you. All right, Mr. Ramirez, I think your client got on.
Yes, Judge, she's on now.
All right. So let me go ahead and recall your case. I'm sorry, what number was that, sir?
Number 38, Your Honor.
Okay, thank you. All right, that's F 4436-21-9 in the interest of a minor child. And I do have both attorneys present. And Ms. Gonzalez, can you hear me? You're on mute. Ms. Gonzalez, can you hear me?
Yes,
All
sorry
right.
about that.
It's okay. Mr. Garcia, can you hear me?
Yes.
Okay. I'm gonna have, it's, Ms. Gonzalez, if you prefer, you can have your camera off, ma'am. The little video at the bottom, you can turn it off if you'd like. I know this is emotional for parents sometimes.
Thank you, ma'am.
All right, okay, raise your right hand. Do both of you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Gonzalez?
Yes, ma'am.
And Mr. Garcia?
Yes, ma'am.
All right, you may lower your hands. Mr. Ramirez, it's your petition, you may begin.
Yes, Judge, this is a case where we're actually set for temporary orders today. We have not mediated. We weren't able to mediate over the holidays. I have been in communication with Mr. Cavazos. He has been as best he can with working with his client, try to get me visits for mom to have with the children. There are several children made the basis of this custody battle. And the main issue at this point, Judge, is A, the party's financial ability to go forward with mediation. B, the fact that at this point, the only issue that we need some guidance on from the court is with respect to the fact that father at this point, the children are with father. My understanding based on my communications and correspondence, telephone calls with Mr. Cavazos is that father's only willing to allow supervised visits at a Peter Piper Pizza, supervised by him until we go to mediation or we have some kind of a graduated scale, Judge. My client feels that there's no reason for it to be supervised. If we have a court order or some Rule 11 agreement, there is a history here between the parties, Judge. But that's the main issue today, whether before mediation and before we have a contested hearing, whether we can get some unsupervised or the court's going to order some supervised, and we can get that in place, go to mediation, and then come back to the court.
Okay, Mr. Cavazos?
Good morning, Your Honor. Jaime Cavazos here for Mr. Garcia. Mr. Ramirez is correct in the fact that we haven't gone to mediation, Judge. We have discussed mediation and we haven't scheduled the Judge. We have mediated informally. We send a Rule 11 right around Thanksgiving, a couple of days before, offering some days, Judge, for supervised visitation. The last time mom had contact with the children was back in June of 2021. Before that, there was an incident. There's an affidavit on file, Judge. I won't go into the facts of it, but in 2019, where dad picked up the children and since then has had exclusive custody. Judge, our communication has always been is that's the mom. That's obviously there are 5 children here, Judge. One of them is 15 all the way down to 7. There's 3 little girls and 2 little boys. But because of the fact of the past, not only the family side, but the criminal side, Judge, we've offered a gradual step mediation to avoid mediation. So a gradual step visitation. We offered Peter Piper, Judge. We haven't gotten anything back. Dad is asking to supervise them personally, which was the last visit she got was supervised by dad. I think we offered 7 visits, Judge, between February and March and April. And see how those go, Your Honor. We did ask about child support, Judge. They have been with dad. She hasn't been paying any child support. We were willing to set it at minimum. We understand logistically and financially it's difficult for them to go to mediation. Dad is not trying to keep the children away from mom. Dad is just trying to keep his children safe. And if he can feel that they're safe, then dad understands that's their mom.
All right. So I'm sure both of you have had a conversation with your clients as to what type of person I am on the bench with cases like this. Am I correct?
Yes,
Yes,
Judge.
Your Honor.
All right. And I'm going to let Mr. Garcia and Ms. Gonzalez know that for almost 20 years, family law is is pretty much the majority of what I practice. So unlike some other benches, I don't mind doing a contested hearing because I was a mediator and I did family law and I served on both sides. I represented clients in Mr. Garcia's position and I represented clients in Ms. Gonzalez's position. And so I'm going to tell you, right now, I'm going to tell you all, if you decide to go with supervised, it will not be supervised by Mr. Garcia. It'll either be supervised by a person that's an independent party that will be paid by both parents, or it'll be supervised by a family member that both, or a friend that both parents can agree on. Now, I have read the pleadings in this, and I'm assuming, Mr. Cavazos, that Mr. Garcia is asking for supervised visitations based on the affidavit that he has on file with the court. Is that correct?
That is correct, Your Honor.
Okay. Which is concerning, but I'm not saying that, I also very much believe in rehabilitation as well. And I definitely don't believe in having children be used as pawns or anything. And I also understand the position Mr. Garcia is in, like Mr. Cavazos said. It's not that he's trying to keep the kids away, it's that he wants to ensure their safety. Now, give me the ages of the kids right now.
Judge, the oldest one, a female, she's 15. The next one is a young man, he's 14. The next one is also a young man, he's 11. And the next one is a female, she's 9. And then the small one is a female, she's 7. And I apologize, the second one, 14, he actually turns 14 later in February, Judge. He's actually 13.
But he's almost 14.
Yes,
He's almost
Judge,
14.
that's correct.
Yes, Judge.
Okay. So these are 5 little ones that we have to really look at. And I understand that your financial means are limited, because right away I would have just assigned an ad litem or an amicus or something so that they can start looking into the situation in an independent manner. However, we're not going to go on without any type of visitation at all. And we're not going to, I'll be honest with you, and you all know it's not reasonable for us to think that in the next 2 minutes, I'm going to make a decision as to what's going to happen with these children. However, I will tell you what's reasonable, because I do have questions with respect to this. So what we're going to do is we're going to hold this hearing over so that I can meet with the attorneys. And hold on. All right, so okay. So I'm gonna have the attorneys, I'm gonna have a link sent to you all for Wednesday at 1:30 for a conference. Have your clients on standby. And we're going to discuss some of the issues. Okay. And we're going to break it down. And the reason that I want your clients on standby is in case I have any questions or I need for them to log in as well. And then I'll decide what it is. Things like this, like cases like this, need to be, there's some serious accusations that Mr. Garcia brings up in his affidavit. And obviously, it doesn't, that is his perspective and his right. And I'm sure Ms. Gonzalez has her side of the story. There's always another side to the story. However, before I go take it any further, I usually take these in baby steps, but I don't lose track of them, because then it's going to extend the time longer where there's no visits with mom. And, it's not to say that a customized possession order is not going to take place. It's not to say that maybe it will, maybe it won't. But before I can make any decisions like that, I'm going to need to talk to the attorneys. But I do want the attorneys to be prepared. Mr. Ramirez, have you had an opportunity to review the affidavit that Mr. Garcia has attached to his counter petition?
Yes, Judge.
Okay.
And Mr. Cavazos ad nauseum, every time we've talked, he's definitely done a good job of explaining to me his client's position and as the why. And, you know, and like the court says, there's a history here. And I can get an affidavit that's gonna do the same and smear Mr. Garcia.
Yeah, no, I understand. That's what I need for the clients to also understand, is because I've been in both of your positions. I mean, of course, I'm going to read whatever you submit, and just because you submit whatever, I mean, the affidavits can go back and forth. It's just like a he said, she said. It doesn't mean that it's not true. It's just that since you have such an extensive history, I'm sure there's a lot on both sides. However, what I am going to say is that I want you to be prepared for that conference on Wednesday at 1:30 for anything that you want for me to consider. So for example, Mr. Cavazos, the accusations that Mr. Garcia has made with respect to Ms. Gonzalez's past, please make sure that you have the cases, and so that I know what the disposition of those is, or if are any of them pending, because those are the questions I'm going to ask with respect to that. And okay, and Mr. Ramirez, then I do want for also you, if there's anything that she wants for me to consider with respect to Mr. Garcia, then also have that. So we'll discuss that on Wednesday at 1:30. You'll receive a special link. And unless you want it in person, an in-person in chambers, we'll just do it via Zoom. If you do want in-person in chambers, I'm fine with that. Just let Ms. Rivera know and we'll accommodate you as well. Okay.
Thank you, Judge.
So we're going to hold this over for right now. So, so we'll hold it over and we'll go ahead and reconvene on Wednesday at 1:30.
Thank you, Judge.
Okay.
Thank
All
you,
right.
Judge. Maybe
Okay.
Judge, may I
Yes.
ask just some clarification? I know with COVID, and is the court entertaining or conducting any conferring with the children?
Yes.
You are. So that's a motion we could file and you would
Yes.
consider?
Yes.
Okay. Would that be through Zoom, Your Honor, or would that?
No, I've done
That's
it
a
via
first.
Zoom, but now that we actually have a location for our offices, we can do it in person. I have a little like meeting room
Yes,
that
ma'am.
we can meet in.
And Judge, being that there are 5 children, do you visit with all 5 at once, or could we just send the oldest, or?
Okay,
And
so
it
it's a
would be up to
case,
my client.
no, it's not just the oldest, it's gonna be all 5.
Okay.
Whether I choose at the time to speak to just one or the other, whatever, it'll be a decision that I make on a case-by-case basis. But when it's multiple children, I'll talk to all the children.
Okay, so make them all available, and then the court will decide on what
Yes.
order or what process to use.
Right. And if we do a Saturday, we can also do the McAllen Public Library. My court coordinator knows how to reserve the rooms there. And the reason that I do that is because I don't like kiddos missing school.
Thank you,
And
Judge.
so if I need to, I can do it after school, but they kick us out of the courthouse and I don't want to be locked in there. Or we can do it on a Saturday.
Thank you, Judge. So then obviously this would probably be after our hearing.
Yes, let's talk on Wednesday.
Okay.
But if you want to get it filed before then, that's
Well,
fine.
we'll file it today, Judge.
And Judge, just so you know, just with the court's comment regarding the person to supervise, I think that gives us some direction also between Mr. Cavazos and I to be able to try to have some framework in place for some kind of visits to start by Wednesday as well.
All right.
Thank you, Judge.
And look, Ms. Gonzalez and Mr. Garcia, it's very difficult to be in this position that you're in. And you've been given a grand responsibility to be parents of 5, I'm sure, amazing children who are already having issues because of the fact that, you know, their parents are going through something. It's natural. And, you know, but you all need to be honest with yourselves too. Like, that's hard. Being honest with ourselves is hard. But, you know, Ms. Gonzalez, if you're not ready for visits, because you know that your children are going to be difficult, then be honest with yourself. And Mr. Garcia, if you really think, you know what, it's fine, she can have unsupervised, I was mad at the moment or whatever, you know, but I won't do an overnight right now, and be reasonable. You know what your children are capable of, and Ms. Gonzalez, you know what your children are capable of, and both of you know what you feel, and so have those candid conversations with your attorney, and I expect your attorneys to also have those candid conversations with you as well. All right. But I will always give you the time that you need in court with respect to these situations. So, we'll meet back on Wednesday at 1:30, and then we'll take it from there.
Thank you, Judge.
Thank you, Judge.
Okay. All right. Y'all have a good day.
Thank you, Judge. My client and I be excused.
Yes.
Thank you, Judge.
Thank you,
Good to
Judge.
see you're doing better, and take care.
Yes. Thank you. I appreciate
Yes,
that.
Judge.
Yes, thank you, Judge.
Okay. Okay, Mr. Lopez, let me re-look at your case. Let me look it up. You said that you thought you had already gotten that file. Okay, let me check. This is number 24 on the court docket.
That is correct.
Okay, sir. No, you do not have a divorce decree on file.
Okay.
So you do need to get that on file.
Okay.
And you have and you can file, once you all sign off on it, then you all can do your order setting final hearing, and we'll give you that date.
Okay, ma'am.
Okay?
Yes, Your Honor. Thank you
All
very
right.
much.
Thank you.
Bye.
All right. Okay, Ms. Trevino, Ms. Olivares is still in that other hearing, but she said she'd come back into the window as soon as she was done.
Okay, Judge.
All right. Okay, so I already know that the one with Mr. Livesay and Mr. Molina, that's going to be a little heated. So hold on. So let me, before I take you up, Mr. Livesay, let me go ahead and see, what is Mr. Sully? What are you here on, Mr. Sully?
Good morning, Your Honor. I'm actually here because Rafael de la Garza filed a motion to withdraw on the case that I'm on. I don't know if he's on Zoom. I'm unopposed to it.
What
It's
number, sir?
27. I'm sorry, Your Honor?
Oh, okay. So Mr. Livesay is also here on that case.
That's correct.
All right, that's CL 153115-I Armando Gamboa et al. Versus Fernando Godina et al. Okay, so we're here on a motion to withdraw that was filed by Mr. De La Garza.
That's right, Your Honor.
Okay. Well, nobody has checked in from his office. Mr. Livesay, do you have any objection?
I have no objection, Your Honor.
Okay, Mr. Sully, and you stated you have no objection.
That's right, Your Honor.
That's correct.
Okay. Then the motion to withdraw is granted, and I will have that order sent up to me. And how are y'all doing on that case? Do you need a status hearing?
I think maybe at some point in the future, we need to this basically stopped because of COVID, but I'm trying to get it geared up again. So at some point in time, we will need a status conference.
Okay, so then why don't we set it up for a 90-day status conference to give you an opportunity to start seeing what can be done.
Okay.
And that's going to be on April the 25th at 9:30. Okay, Mr. Sully, anything else?
No, thank you, Your Honor. That's all I had before this honorable court.
Okay, thank you.
Thank you, Your Honor.
All right, so Julianne Abrego. Julianne Abrego. Okay, Ms.
Yes, Your Honor.
Abrego, are you here on the divorce of Julie Garza versus Jorge Garza?
Yes.
Your Honor, I'm sorry to interrupt. I just realized that I'm scheduled to be out of town on April 25th. Would it be possible to have a different date?
Sure.
On our
Let me
case,
just check to see. Mr. Livestay's still on anyway.
Yeah, I have no objection, Your Honor.
Okay, let me double check just to make sure the next Monday. Yeah, we're good. The next Monday is May 2nd.
yes, Your Honor, that should be perfect.
Okay, so then we'll go ahead and do it for May 2nd.
Thank you very much, Your Honor.
All right. Okay, so Ms. Abrego, let me
Yes,
just
ma'am.
go ahead and look up your case very quickly. Huh. Okay, for some reason, Ms. Rivera, can you check to see if you can open up the PDF of her petition for divorce? It's not letting me.
Judge, I received the same notification. I'm not sure if it's all of our system, but it is not allowing me as well.
Okay. And it's not
Yes.
allowing me to do the waiver either.
Your Honor, I can open her petition.
Okay. Do they have any children?
No, Your Honor.
No,
Okay.
ma'am.
All right, Ms. Garza, so do you have no children and do you have any debts?
No, Your Honor.
Okay. And how about community property?
No, Your Honor.
Okay. So are you going to be asking for a name change?
Yes, Your Honor.
All right, let me have you raise your right hand. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You may lower your hand. Will you please state your full legal name for the record?
Yes, Julie Ann Abrego Garza.
Okay. And Ms. Garza, you are currently married to Jorge Garza, is that correct?
Yes, Your Honor.
What date were you all married?
In December 15th.
What
Yes, of
year?
2020.
I'm sorry?
2020.
Okay. All right, and what date did you separate?
In October of 2021.
Okay. And ma'am, are you asking for a divorce today because your marriage has become insupportable because of discord or conflict of personalities between yourself and Mr. Garza?
Yes, Your Honor.
And you and Mr. Garza do not have any children together, is that correct?
Yes, Your Honor.
And you are not expecting a child at this time from your marriage?
No, Your Honor.
And are you also saying that you have no community property debts?
Yes, Your Honor.
So any debts that are under your name, you will pay, and any debts that are under his name, he will pay.
Yes, Your Honor.
And also, you have no community property?
No, Your Honor.
Okay. And I don't see that you have a divorce decree on file.
No, we haven't filed it yet, but we've signed it. I will be turning that in today.
Okay, and you're asking for a name change to Julie Ann Abrego, is that correct?
Yes, Your Honor.
Okay, make sure that's on that divorce decree.
Okay.
All right, and he signed that decree?
Yes, Your Honor.
Okay, we'll get that filed as soon as possible so that we can get that sent over to me so I can sign it.
Okay, Your Honor.
Okay, the court grants the divorce today. However, just so you know, you're not divorced until I sign that divorce decree.
Okay, yes, Your Honor.
Okay?
Thank you so much. May I be
All right.
excused?
Yes, best of luck to you.
Thank you.
Go ahead and set a tickler for February the 11th to make sure that the divorce decree is filed. All right. Yes, Mr. Lopez. Yes, Mr. Lopez. I can't hear you.
Can you hear me there?
Yes.
Yes, ma'am. Your Honor, I just got off the phone with my wife and we were both, since we're both in agreement and we're ready to move on, we've been waiting a long time for this case to finalize. Is there any possible way you could give us a sooner date?
Yes, but I won't give it to you until the divorce decree is on file.
Okay, I will have that filed this week.
Yeah, when you file it and you file your order setting hearing,
Okay,
then you can get a sooner date. But if you don't file the divorce decree, I'm not going to give you a date.
okay, understood.
Okay. All
Yes,
right,
ma'am.
thank
Thank
you.
you very much. Bye.
Okay, the young lady that's on Lopez's iPad, who's that?
That's the wife, Your Honor.
Oh, Laura? Okay.
Yes, that's me.
All right. So
Thanks.
you need to get with him to sign that divorce decree and then we'll go ahead and get you set up sooner. Okay?
Okay. Okay, thank you.
All right. Yes, ma'am. Thank you. Okay, who's Susie S?
Right here, Your Honor.
Okay. What number are you on the court's docket?
Number 23.
Okay, that's F 5576-19-9.
That is correct, Your Honor.
All right, give me one moment. Okay, so you filed a motion to consolidate, is that correct?
Yes, I did, Your Honor.
Okay. And the other cause number is F-2481-18-I. Is that correct?
-1. It's a number 1.
Oh, it's 1. Oh, okay.
Yes.
Okay. And that other cause number is also dealing with your children. Is that correct?
Yes.
Okay. Okay, then the court is granting the divorce. The court is granting your motion to consolidate. And you have a divorce decree on file. Is that correct?
I do. Last time we were on in October, we were both present and we discussed it. You discussed it with us and you did mention that the only thing missing was the motion to consolidate and that he didn't need to be present on this hearing.
Correct. Do you recall on that date, did we prove up the decree?
Yes.
That's the date that we went ahead and proved up the decree. So all we have to do was a motion to consolidate, right?
Okay. Yes, Your Honor.
All right, then I'll have the order granting the motion to consolidate and then we'll go ahead and have this decree forwarded to my queue so we can sign off on it.
That sounds great.
Okay.
Thank you.
All right, thank you. All right, good luck to you.
Thank you.
Thank you. Okay, Ashley Sosa. Ashley Sosa.
No, Your Honor. Ashley Sosa
Okay.
here.
All right, and what case, ma'am?
This is number 41, Your Honor, on the docket.
Okay. Your client's on, right, Ms. Sosa?
Yes, Your Honor. But Mr. Oscar Vega, who's the attorney for the other side, is not.
Correct. Have y'all had an opportunity to talk about your motion?
Your Honor, I spoke with him and he had told me that he was going to withdraw, but he hasn't filed anything. So I tried calling him right now. I didn't get an answer. So.
Okay. And I know you've been on for the whole time.
Yeah.
Do you want to continue? I'm still going to we still have one more contested hearing. So it's up to you if you want to stay on.
I can try calling him again. He said he was going to withdraw. I don't know if we can get another date as well.
I can give you another date for right now. I can give you March the 21st.
Okay.
at 9:30, and if you need it sooner, just let us know. And that should give him plenty of time to withdraw.
All right, Your Honor, I will let him know.
Okay, I'm sorry you had to wait this long, you and your
No,
client.
it's okay. It's fine.
Okay.
Thank you so much.
All right, thank you.
May I be excused, Your Honor?
Yes, you certainly may,
Thank
and
you.
so may your client.
All right, thank you.
Yes, okay, Jonathan Sanchez. Jonathan Sanchez?
Yes, ma'am.
Okay, sir, what case are you here on?
I think I was number 13 on your docket, ma'am.
Yes, did you have an attorney, sir?
No, ma'am.
Okay, so this was F 3205-19-9. Have we heard from attorney Juan Ramos?
Judge, on this case,
non-suited.
yes, but we're pending the order. The notice of non-suit was filed, Judge, but there was no order.
Oh, okay. So the parties reconciled? Mr. Sanchez, did you and Miss Alanis reconcile?
No, ma'am.
Okay. So what was filed as a non-suit? Was that from the AG's office or from Mr. Ramos?
Mr. Ramos, Your Honor, it reads that petitioner does not wish to continue to pursue the claims against Mr. Sanchez.
Oh, okay. Mr. Sanchez, your wife has filed a notice of non-suit, which means that she does not want to go through with the divorce.
Okay.
Therefore, I suggest you, if there's anything that you want to do, if you don't want to stay married, then you need to discuss it with her and you have to do your own pleadings. But if you're fine with that, well, then you all can live your life however you'd like. Okay.
Yes, ma'am.
All right. But other than that, your case with us is already over.
Thank you. May I be excused, Your Honor?
You certainly may.
Thank you. You also have a good day.
Okay. You too. All right. Crystal's iPhone.
Hi.
Hi, Crystal. What name?
Crystal Alfaro and Jose Tapia Vera.
Do you know what number?
No, I don't. Fela's was supposed to be on. Fela Olivares.
Your Honor, let me get Fela Olivares.
Oh, okay. So hold on. Is she ready?
Let me get her, Your Honor.
Okay.
Your Honor, they're just giving her another reset date and she's coming over here. I don't know if you want me to.
I do have one other case that I can take up and wait.
Okay, Your Honor.
Okay, let me go ahead and do that.
Thank you.
All right, let me go ahead and call CL 24259-I, Susana de la Rosa versus Fernanda Quintanilla et al. Announcements?
Christina Cunningham on behalf of defendant BBVA USA.
Good morning, Judge. Javier Villalobos for De La Rosa.
Good morning or good afternoon, Judge, at this point. Juan Molina for Maria Fernanda Quintanilla, along with Keith Lifesay.
Okay, and we're here on defendant's first motion to compel.
Yes,
All right,
Your Honor, if you
Go
will
ahead.
recall, this case involves, it's a breach of contract case or a contract case involving Maria Fernanda Quintanilla and her deceased husband, Raimundo de la Rosa. And he passed away on November 4th of 2020. By way of factual background, Judge, this is the case where they knew each other since the 70s. Mr. De La Rosa managed hundreds of thousands of people, managing H&H Meats that was owned by Congressman Ruben Hinojosa. And he also started up his own business. They had a very long relationship with each other. They ended up also raising a blended family. At some point along the way, they were, life got a little complicated and they were married twice and divorced twice. The point is they were not strangers. They knew each other very, very well. In terms of why we're trying to seek information from Javier is because we've been dealing with this case since November of that year of 2020. Here we are in 2022, and we still don't have a legal theory other than Javier Villalobos just saying that it's his money, I guess, or his client's money. And so it's very difficult, as you know. There is no trial by ambush in the state of Texas, and so what we've been trying to figure out. Okay, Javier, tell us what your legal theories are, because the way when my client walked in, I saw this as a very simple one-page case. It's a payable on death case, and the contract is between the account holder and then BVA Compass, which is now merged into PNC. And so typically in these sorts of situations, it's not complicated, and the beneficiary of the payable on death gets their money, which she did. The funds were dispersed via cashier's check to our client, Maria Fernanda Quintanilla, and all was fine for a week or two till Javier filed an ex parte injunction TRO in November. It was heard by Judge Rudy Gonzalez, so on and so forth. Another ex parte injunction TRO was signed, leading up to a temporary injunction that was signed on this December 29th of 2020. And so I still see then and now that this is still a very basic case, Judge. It's not a complicated case, but we still need to know the legal theories in order to set up for the future. So that's kind of procedurally and factually where we are. And there's probably a couple of other items that you need to know, Judge, if you'll allow me a few more minutes.
Yes.
Okay. On July 22nd of 2021, because remember the injunction was signed December 29th, the day after we appealed this case, and we got a favorable ruling by the Court of Appeals on the 22nd day of July 2021. Follow me, Judge?
Yes.
Okay. And the Court of Appeals basically stated this temporary injunction is void. And in other words, the Court of Appeals ruled in our favor. So that's point one. Point two is that, and I'm sure Christina can address this point, is that unfortunately, because this case has dragged on, we're now caught in a quagmire of sorts, right? Because the position that the bank is taking is we need to have the court hear this on the injunctions, because they're forbidding us to move forward. And I'm looking at it like, okay, simple one-page contract case. The Court of Appeals eventually agreed in terms of the account holder. The situation is this, Judge, that our position with the bank is that it's clear to us that we got a favorable court ruling. Moreover, it's also clear to us that the bank's position is, let's put this money up in the registry of the court. So the important issue here is that because the bank is seeing this as you guys fight it out, we thought this was going to be quickly resolved in November, December of year 20. The bank is saying, hey, we're owed 60% of the proceeds already. So from the 25,000 and change, the bank is taking the position that we're owed roughly $15,000. So in order to move forward, and I know there's some moving parts, Judge, but in a nutshell, the reason why we wanted to move forward with and compelling Javier Villalobos to tell us what his legal theories are, so we can know what it is that we're fighting over. To this point, he has not done that. So that's why we have all these motions set that we're trying to move this case forward, balanced with the fact knowing that the bank, each hearing that we've had where nothing results, the bank is billing, and that's pursuant to the depositor agreement that the owner of the account, in this case Maria Fernanda Quintanilla, my client, has with them. So it raises a lot of issues, right? Because currently, let's say, for example, Judge, that now in the payable on death clause in the account, her heirs are the new beneficiaries. Well, what if she decides to change it next week or next month? This case will never end. So that's why we had proposed a motion to enforce the Court of Appeals mandate, which is also on file and set for today. And we have exhibits A, B, and C, which I think is the path of least resistance, makes the most financial sense, and moves this part of the case forward, Judge.
Okay. Ms. Cunningham, were you going to add to that before I get to Mr. Villalobos's response?
Your Honor, all I was going to add is that, yes, we were finally able to serve the fourth child of Raimundo de la Rosa, that being Raimundo de la Rosa Jr. And once we had all of the potential heirs before the court, we filed a motion to allow interpleader. We have contacted the clerk trying to get hearing dates. So that motion has not been noticed for today. But Mr. Molina is somewhat correct in that, pursuant to the deposit agreement, when there's a dispute as to the ownership of the funds, we are allowed to place a hold on the funds, and the bank did that, and it is continuing to hold the funds, not simply because of the injunction, but because of the deposit agreement. And thus, we do want to interplead the funds into the court. The interpleader statute does allow the bank to recover its attorney's fees, which before today were $12,971.40. And the account balance is $24,801.89. So Mr. Molina is correct that the bank's attorney's fees are slowly increasing. And what I have tried to minimize that, in that I don't review everything that's filed by the parties in detail. I've tried to limit the bank's fees. It really has been the hearings and the cost, of course, of serving the 3 other children who were not party to this lawsuit already.
Okay, Mr. Villalobos?
Morning, Judge, or actually good afternoon. Actually, Judge, I kind of agree with the bank too, and we're trying to keep them out as much as possible. However, I totally 100% disagree with what Mr. Molina said. I don't know what he's trying to do with mandating. The Court of Appeals said the TRO needs to go away. We agree. We did agree. That's why we didn't even file. So I don't know what he's trying to do. As far as compelling, he can, excuse me, Judge, he can do a deposition. He can do whatever he wants. But as for disclosure, I'm just going to put whatever is necessary, and that's it. So if you want to, my clients, we're available.
Okay, but do you have anything to add to the Mr. Molina's specific concern? Is that the response to the legal theories that you plan to present if it goes to trial, what those are? Do you have an issue with expanding on that?
I can, Judge, but the thing is, she is not an owner of the account, and she is not the payable upon death beneficiary. That is it. What else can we put?
Okay.
And
So-
now if you want to oppose, you can oppose.
Judge, can I respond to that? And, you
Here
know,
comes the tag team.
well, I'm the one who filed the motion to compel, and he's got absolutely no facts stated therein. How he comes up to the conclusion that she's not the owner of the account when the account document says she is the owner, I have no idea. And the other thing is well, instead of that, he goes and says that Mr. Molina's client and mine is a thief. Well, you know, I know that those things may come trippingly off the tongue for Mr. Molina, but that's a pretty serious allegation. If you're going to make something like that, then you need to factually back it up. And you need to be able to say why and how that my client is a thief. You know, she has the POD, you know, and what is he saying? This is not a POD account? Then I would like to know that. And that furthermore ties into to what we were asking for on this. We were asking for a status conference, and we've also asked it for findings of fact and conclusions of law. So this court and Mr. Villalobos will tell us specifically what facts need to be tried, because I can't figure it out. Mr. Molina can't figure it out from at this point. Saying, oh, she's not an owner of the account. Well, she is. I mean, what are they trying to do? Tear up the deposit agreement? Well, what legal theory allows them to tear up the deposit agreement? And so it's you know, you've got to be more than this, that we can't tell our client why summary judgment wasn't granted when everything was undisputed. Furthermore, you know, I understand the bank's position that doesn't want to get caught or held liable, but the Court of Appeals was pretty specific, saying that injunction was void. It's wiped off the face of the earth, essentially. And so we need to go back to what was before the injunction, whereas my client Mr. Molina's and my client had the money in her hands or was free to use it. And so that's what we need to go to. And let's get the bank out. And then if Mr. Molina can eventually, if Mr. Villalobos can eventually establish a claim, let's do that. But let's, you know, quit, you know, let's just quit all the nonsense of just saying, oh, well, she's a thief, or, oh, she's not an owner, or, oh, it's not a POD account, because it is.
Okay, so it sounds to me that everyone is leaning towards the agreement that Ms. Cunningham and her that her client should be, or Mr. Molina, you're shaking your head. You don't want the bank out?
I want the bank out, but I think Javier seemed to agree with our motion to enforce the Court of Appeals mandate, and the bank would be 100% out. That's what it sounds like we're in agreement to.
Your Honor,
Judge.
well, go ahead, Mr. Villalobos.
I would totally disagree. Actually, I think that the bank would have to be a little concerned to say that the Court of Appeals rule, go ahead and give them the money. So, but I mean, they can speak for themselves. But I kind of need to also remind the court that there's another TRO with $275,000 pending in the Court of Appeals. And that one, there was evidence, there was a hearing, and we're still pending that one. That's why I filed a motion to transfer from this court to the probate. Now, and I disagree with what Mr. Life is saying. We agree that it's a payable upon death contract, but Ms. Quintanilla is not the beneficiary. Now, in the Court of Appeals, they agreed that it was not their account. So if it's not their account and she's not the beneficiary, I see it as she really doesn't even have standing. So that's where the issue is.
Judge,
hold on. Let me allow Ms. Cunningham to finish what she was going to say right before Mr. Villalobos, and then I'll take you up. Ms. Cunningham?
Your Honor, what I would say is, yes, initially the bank froze the account because of the temporary restraining order, which turned into an injunction. However, even with the Court of Appeals ruling that the injunction was improper and setting that aside, the bank still is now aware that multiple parties are seeking claim to the funds in the account. And under both the deposit agreement and the interpleader statute, the bank is entitled to interplead the funds. I would say if the court ordered, of course, the bank would comply with any order of the court, but I would say if the court's order is that the Court of Appeals decision is enforced, but it doesn't go so far as to state that the bank should deposit the funds into the registry of the court or release those funds to Ms. Quintanilla, the bank's still going to hold the account pursuant to the interpleader statute and the deposit agreement and seek to interplead the funds into the court's registry.
Okay, Mr. Livesay?
First of all, as to Ms. Cunningham's concerns, the order that we have proposed has the bank giving the money to Ms. Quintanilla and being absolved. And so I think that takes care of her concerns. I seriously wonder if Mr. Villalobos actually read the Court of Appeals opinion, or that was just something he came up saying, oh, that they ruled in her favor, but she really isn't entitled to the money. Well, that doesn't make sense. You can't have it both ways. If the Court of Appeals thought that my client wasn't entitled to the money, they wouldn't have ruled in her favor. And so, it's that, and the Court of Appeals opinion is attached as an exhibit. The court can read it, but it's pretty clear that we're entitled to the money, and let's give us the money. Let's get the bank out. Let's discharge them. And so we can just continue on with the rest of this case.
And
Okay,
Judge,
so,
this is remanded for further proceedings, not that you win.
okay, so I just want to make sure we're talking about the Court of Appeals opinion by Justice Tijerina that was
Right.
filed with this court on July 26, 2021, correct?
Yes,
Right.
Your Honor.
Okay. So, and there, the way I understand it, because of course I've reread it several times, is that Justice Tijerina is stating that the temporary injunction was to be dissolved and the case remanded to the trial court for further proceedings. Is that correct?
Yes.
Correct.
Okay. So then his analysis is all on the temporary injunction and that it should be void. So I didn't see anywhere on here that there's an interpretation that they were making a ruling stating one way or another with respect to the proceeds. Did I miss that somewhere?
No, but what is the effect of the order being void? It goes
Okay.
back to the status quo before the injunction was filed, basically that Ms. Quintanilla's got the money in her hands.
Okay.
And that's the way you have to look at this.
Okay.
Judge, and if they spend it or pay attorney's fees with that money, I'm gonna sue Mr. Molina and Mr. Livesay. And now the bank also knows that there's issues with the money. Before they didn't know, nobody knew. Now everybody
Okay.
knows.
So you are stating that the bank should not have used any part of that $24,000 to pay their own attorney's fees?
No, Judge, that's something we can fight over later on. What I'm saying is if the bank wants to interplead, go ahead. We'll fight anything regarding fees later on. However, if the bank gets the money to Quintanilla, they're going to be in a world of hurt because they know that we're making claim to it. We know that they got divorced in 2012. We know that she never utilized that account in 2012, 2013, 14, 15, 16, 17, 18, until She was told by one of the heirs that her name was still there. The divorce decree stated, this is your accounts, these are your accounts, and that was it.
Okay, but this is the thing, Mr. Villalobos, the bank's
Mhm.
motion to interplead is that's what that's what their argument is today. That they want to be allowed to place the money in the registry of the court so that they can already take what's owed to them or pay themselves,
And
put the balance in the registry of the court, and that way Ms. Cunningham does not have to use any more of those monies as per the agreement that we all sign when we get the bank, open up a bank account. So
And Judge,
that's what
this
I
is-
need
this is-
to make sure that we
okay.
all understand that that's what Ms.
Okay.
Cunningham is asking for.
And I would have an objection to the amount of attorney's fees. As far as putting the money in, kind of stay out, I have no issue. But litigate the attorney's fees at a later date.
Okay, so I don't think that at this point there's anything on file to litigate the attorney's fees that the bank has charged. So you would need
Other
to have
than,
something.
Judge, I would have to make sure that it was reasonable and necessary in what it is. And actually, I don't even think it's set for today, but those are the issues I have with the bank. But we've gotten to the point with the bank that we have not filed suit against the bank, but we may. And that's what
Okay.
I'm trying to figure out what we're gonna do.
Your Honor, that's why we filed the interpleader, because
Correct.
for that very reason. And the interpleader statute, which is a statute, says the bank is entitled to its reasonable and necessary attorney's fees, and attached to my motion is an affidavit as well as redacted attorney's fees invoices proving up the reasonableness and necessity of those attorney's fees. And I agree, this is not set for hearing today, and the bank may be willing to negotiate on those attorney's fees, but what the bank will not do is deposit the funds into the court registry without addressing the attorney's fees. I've done over 100 interpleaders, and it's standard that the attorney's fees are deducted and then the remaining funds are put into the registry of the court.
Well, and if we can't agree, Judge, then let's set it up for hearing and let me file whatever appropriate motions to respond.
Okay, so I'm gonna give, as to the motion to allow interpleader, then I'm gonna allow y'all to confer with that. And Ms. Cunningham, if you need a hearing on it, if you can't get an agreed order and you need a hearing, just go ahead and file an order setting hearing.
Okay, thank you, Your Honor.
As to the motion to enforce the compliance, let me see. I'm sorry. As to the motion to compel a more specific answer, then I'm gonna allow Mr. Villalobos to expand on his answers on the request for disclosure. He has 30 days to do that, so that and the whole point is to be more specific on the legal theories. And so we'll go ahead and the deadline for that will be February the 24th. And Mr. Livesay made a, now that I understand, I think in everything that has gone on with this case, it wasn't until we broke it down for right now when Mr. Livesay mentioned, okay, if it was to be dissolved, then yeah, it goes to a status quo. So now what I'm gonna do is I'm gonna hold that over so I can go back and look at what was done at that time. And on that motion to enforce compliance with the appellate court mandate, because now I know what you're trying to do. I understand it now. We're coming back on that on February the 20th. Hold on. We're gonna come back on that on February the 28th at 2 p.m. So if you're needing to file an order setting hearing on your motion, Ms. Cunningham, go ahead and put February the 28th at 2 p.m. on there. That gives you a little over 30 days to discuss with everyone with respect to the attorney's fees.
Thank you, Your Honor.
Okay?
Your Honor,
Go ahead.
for what it's worth, the account signature card, there's two options here. It's either Mr. Molina's client's account, or it is a non-probate asset that passes to the POD beneficiary, Maxi, I'm so sorry, I'm forgetting his name.
Máximo.
Maximo de la Rosa. I mean, those are the two options based on the account record.
Okay, so, and I think the signature card is attached as an exhibit to one of your motions, isn't it? Because I saw it.
Yes, it is.
Okay, can you just refresh my memory as to which motion it's attached to?
It is attached to the, I apologize, it was the BBVA's second amended answer and counterclaim, cross-claim, and third-party claim for interbleeder.
Okay. Okay, let me just look up one more thing. Do you all have, competing orders on the motion to transfer?
Yes, Your Honor. I
Yes.
submitted my order, granting the motion. I'm sure you
Yeah,
did too.
I'm sure we submitted orders denying it, but I can't see that. I'm not at that computer right now.
Okay, it said I don't see. Actually, I don't even see, I don't know if my court coordinator can see that, but I don't even see the order with the order granting. I see the motion to transfer order. Yeah, the orders are not on file, gentlemen and Miss Cunningham.
All right, I'll be sure to file one today, Your Honor.
Okay,
Will to Judge.
so get those orders on file because that way I can sign off on one of them.
Sounds
Well,
good, Judge.
Judge, you've already made a ruling that you were denying their motion to transfer.
I think that was at the.
Yes, okay, so I did rule, right? Because I didn't see that in my notes.
The prior hearing, I think.
Okay, but I don't have an order on file. That's why I was wondering, had I issued the ruling?
Okay, we'll make sure that there's an order on file, Your Honor.
Yes, that's why when I saw it, I said, I feel like I made the ruling, but I didn't see the notes on here and I didn't see the order. So then I second guessed myself. Don't make me second guess myself. Okay.
It's the only orders that Your Honor has signed, and their orders that have been submitted was the order denying the second motion for summary judgment. That was signed on October the 13th. But you are correct, Judge. Other than that, no other orders have been filed.
Yeah, so Mr. Livesay, if you can get that filed today, please.
Yes, I will.
Okay, then I'll look out for that. And I know that you have your request for the conclusions, for the findings of fact and conclusions of law. And well, I know you have your first, second, and third request. However, I'm doing some research of my own with respect to that. So it's not that I have forgotten. It's just that the guidance that I'm seeking has been a little slow for me. So I haven't forgotten you, Mr. Livesay.
Well, thank you, Your Honor. And I apologize if I was a bit dense, but my wife says that all the time.
It's fine. Okay.
I agree with his wife.
Okay. Y'all have a great day. Okay. Thank you so much for
Thank you,
waiting.
Your Honor. Thank you,
Okay.
Your Honor.
All right. Y'all take care.
Bye-bye.
All right, Ms. Olivares?
Yes, Your Honor.
You had plenty of time to probably even do another contested hearing.
No, we did good, but Ms. Trevino and I were texting back and forth so we can be ready for you because it's been a long day for you.
Yes, it's okay. So then F 5593-18-9, can you please read the style of the case? Because I didn't have it on my thing.
Yes, it's in the matter of the marriage of Crystal Alfaro and Jose Adriel Tapia and their 2 children.
Okay, so Mr. Jackson was on earlier with his client. They stated that they were in agreement with the order, or I'm guessing the terms that you sent over to them. So are those the same terms that your client will be testifying to?
Yes, Your Honor, it's the agreed final decree of divorce with the exception of Ms. Trevino is going to correct us on the arrears.
Okay.
Just slightly.
All right, so then Ms. Alfaro, may I please have you raise your right hand?
Your Honor, she needs to put her video on.
Okay, there. Oh, sorry.
There.
Sorry,
Okay.
because my camera's broken.
All right, can you please raise your right hand?
Yes.
Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, you may lower your hand. Ms. Olivares, you may proceed.
Yes, Crystal, at the time that you filed this divorce against your husband, you were a resident of the state of Texas for 6 months and 90 days in the county, is that correct?
Yes, ma'am.
Okay, and out of that marriage, you had your 2 children, is that correct?
Yes, ma'am.
Ian, I-A-N, and Nolan, is that correct?
Yes, ma'am.
And you were married on or about April 25th, 2014, is that correct?
Yes, ma'am.
And you and your husband separated on November 4th, 2017. Is that right?
Yes, ma'am.
And you're asking the court for a divorce under the grounds of insupportability and there is no chance of reconciliation. Is that also correct?
Yes, ma'am.
Okay. And you and your husband accumulated a home that you were buying under contract, but you have already negotiated a settlement with our 3rd co-respondent, Jose Israel Tapia Vera. Is that correct?
Yes, ma'am.
And we will, of course, at the time that the divorce decree is signed by this honorable court, he will be completely out of the case because he's going to pay you a sum of money. That is not part of this agreement. Is that correct?
Yes, ma'am.
Okay. And in reference to that home, just for the record, it will go back, once he pays you the complete amount, it'll go back to Jose Israel Tapia Vera.
Yes, ma'am.
Which is your brother-in-law, correct?
Yes, my ex-brother-in-law, yes.
Well, he's still your brother-in-law, you're still married. Okay. And other than your, in here, let me go to the decree, please. In the divorce decree, we have you as the primary custodial parent. And let
Yes,
me go
ma'am.
over there just to make sure I'm not. Without regard to geographical location, is that correct?
Yes, ma'am.
You're both joint managing conservator, and again, like I said, with you being primary.
Yes.
And he has standard possession, the old standard possession. Is that correct?
Yes.
The one within 100 miles.
Yes.
Okay. And in reference to, of course, you'll have the right to the education, the choice of education and medical, and that's all in this decree. Is that right?
Yes.
In reference to the child support, you and your husband have agreed to leave it as we had it in the temporary orders of $1,631.40 beginning February 1st, 2022, with a step down of $1,305.12. Is that correct?
Yes, ma'am.
Now there is a judgment, the judgment that we had calculated or had put that amount in the divorce decree, page 21, is 37,793.41 as of December 31st, 2021. And that includes child support and medical. Yes?
Yes.
But you understand that the Attorney General is here, Ms. Isabel Trevino, the attorney for the Attorney General, and she's going to correct those numbers, and that page will be changed according to what the correct numbers from Ms. Trevino. You understand that?
Yes.
Okay, and it's not a lot of difference. So I will defer that to Ms. Trevino as soon as I finish here with you. Other than personal effects, since you already took care of the house, you are keeping the furniture, personal effects, clothing, jewelry in your possession, and so is he. Is that correct?
Yes.
And if you have retirement, you will keep yours. If he has retirement, he will keep his. Is that correct?
Yes.
And you're driving your vehicle. Now, the time that we prepared this was a 2018 Ford Explorer, your vehicle. Do you still have that vehicle?
Yes.
Okay, so that will be your vehicle allotted to you in this division. And Mr. Tapia will have the 2014 GMC pickup. Is that correct? With a debt thereon, is that correct?
Yes.
Okay. And you and your husband have agreed that all the debt under your name as of November 4th, 2017, you will pay, and he will keep, Jose Adriel Tapia will keep all the debt in his name as of November 4th, 2017. And is that your agreement?
Yes.
Each of you will pay your own attorney's fees. Is that right?
Yes.
And you have the tax exemption of the 2 children. Is that correct also?
Yes.
Okay. And do you understand that once the judge signs this divorce decree with your signatures, that the temporary orders will be resolved as of that date, and we are not going to reserve them or keep them, that you can come back and then do another enforcement on all this child support? You understand that?
Yes.
And that child support will be paid, but in 2 different payments in addition to your child support. And that's what you've agreed to today. Is that correct?
Yes.
And you don't have any need to change your last name because you always have been known by Crystal Alfaro.
Yes, ma'am.
Okay, and you're asking the court for a divorce. Is that correct?
Yes, please.
And the reason you say please is because you want to buy a house for your children, correct?
Yes, ma'am. That's why.
Okay. And did I forget anything that we need to tell the court?
No, ma'am. That's all.
Okay, I'll pass the witness, Your Honor.
Okay, Ms. Trevino, do you have any questions of Ms. Alfaro?
Yes, Judge, and I have, if I'm gonna ask Ms. Olivares to repeat the step down on the child support.
Yes, the child support is 1631.40 as of February 1st, 2022. And the step down is 1,305.12 when the first child emancipates.
Okay. Okay. Judge, I'd like to offer into evidence the State's Exhibit A, the financial activity report, which was filed on January 10th, 2022.
Okay, any objections?
I have no objection, Your Honor. I have received a copy this morning.
Okay, that'll be admitted and it'll be marked as your exhibit. Is it Exhibit 1?
Yes, Your Honor.
Okay. Go ahead.
The state is requesting, Judge, a child support arrears judgment in the amount of $35,723.59 as of December 31st, 2021. The state is requesting, Your Honor, that the payment plan start at $250 a month beginning February 1st, 2022. with a step up to $1,472.56 and a final step up to $1,881.40. The state is also requesting a medical support arrears judgment in the amount of $2,069.82 as of December 31st, 2021, to be paid at $30 a month beginning February 1st, 2022.
Okay, so the final step up was how much? I'm sorry?
$1,881.40.
Okay, got it. And how much was regular medical support going to be, Ms. Olivares?
Let me see what we have. You're correct, Judge. We have,
I think it was 75.
yes, 65. And that's because the children are under that Medicare. Is it Medicare or Medicaid? One of those, I'm not sure.
Oh, okay, so then it's 65?
No, actually, they don't have insurance right now because Adriel, their dad was saying that he was gonna get it with their work, but he never got it, and it's already closed down, so they didn't get to get insurance.
Oh, well, that changes
Yes.
that part, Judge. So we need to put then, it was $75 that I have written. I just can't seem to find it.
Okay.
That's
Well,
what, right. That was what was agreed in the original temporary order, but at that point, they were under tax care.
I found it. It's, we put on page 28, they had agreed to $125 per month as of February 1st, 2022. And if he does, because that would include the government assistance.
Right.
So if he doesn't, we have provisions here that then he has to provide for the health insurance.
Okay, so you do have the provisions in there.
Yes.
Okay. All right, anything else?
Not on our part, Your Honor.
Okay.
No, Your Honor.
All right, then the court is granting the divorce between the parties, accepting and will approve the agreement as read into the record, and will be set forth in further detail in a final decree of divorce to be signed off by the parties and all attorneys of this matter. And let me see, how much time do you need, Ms. Olivares?
Judge, it's ready. We have it, everybody has it already. So we want to, like Ms. Alfaro said, she really needs like it today or tomorrow. So I'm gonna try Mr. Jackson to sign it.
All right, so then I'm just gonna put a tickler for Friday then, for January the 28th.
Yes, Your Honor, please.
All right, anything else?
Not from us, Your Honor.
All right, then you may be excused.
Thank you so much, Your Honor. Have a wonderful day, all of you.
Thank you.
Okay, bye. Thank you, Isabel.
Thank you. Okay, so nobody showed up on CL 194619-I, that's number 10 on the court's docket. Was there any call that was made?
Judge, defense did file a notice of removal to state court. That was the notice stated. It was removed.
Oh, okay, to district court?
Yes.
Okay. And then, hold on. And on number 20?
On number 20, Judge, there is an agreed order on file.
Okay.
They filed it this morning, I believe, or yesterday, or I guess the weekend, over the weekend.
Okay, 25?
On number 25, Judge, Mr. Flores does have COVID. He did send me an email, and opposing counsel did email me as well, and I'll be in contact with them for them to file an order resetting.
Okay, number 26?
There is nothing filed on that one, Your Honor.
I'm sorry, what?
There's nothing filed, Judge, and they did not contact us.
Okay, and was the motion to withdraw, did they already urge it, or do they have they need to file an order resetting hearing on it? Because since the other parties pro se, they need to also be here. So go ahead and let Mr. Aguilar know.
Yes, ma'am.
Okay, number 32.
Number 32. There was an order resetting file, Judge.
Okay. And I believe that's it. Okay, that concludes to this morning's docket. We are now off the record. Stop